Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican police service London. I didn't ask you to interrupt.
Is that correct?
Literally not true.
Welcome back to the Court of Public Opinion. I'm the Recovery Addict. Thanks for joining me this afternoon. Thought we could hit a rap song. I've got to... I was busy playing up for Mrs. R.A. So... Oh my goodness. Oh, let's see. I turned in my change of address this morning. I have moved to the lake. Hollaback, that's awesome. That is awesome. Asher says I tried code. Oh, sorry, it's fine. It's fine. I think it's shut down now, right? I just left it running a little bit long. It's good. It's good. Yeah, it's time. It's time. We're back. Is it? Well, it's supposed to. It says back at 2 p.m. Right? Look, when we look at the judge. Sorry, let me turn this off right here. Upstream here 4. There we go. He says back at 2. Back at 2 is what he said. All right, we have a brand new winner. Is it Marique? Is it Marique M? Marique, congratulations. You are first in chat today. You're thinking cool, right? Well, yes, and then also no. We enjoy our peace and quiet. You wouldn't know that if you listened to the rap song that we just dropped on the last live, but you were first in chat, so we're going to punish you for breaking the silence, Marique. Don't take it personally. It's actually not you. It's not. Well, it was you. And so we're punishing you with internet ownership, which means you just have to take care of the internet and everything connected to it worldwide, just until we go live again. Which, unfortunately for you, it's a Friday afternoon. We probably won't go live over the weekend because I will be building my bathroom, or else I won't have one starting next week. So yeah. That's where we are. I'm testing out my new toy, which it's not working quite well yet, but it has this really cool screen. Cloud Dock 2 shows memory and everything, but it says it can't write to it. I think I need to format the drive still. All right. Anyway, Marique, congratulations and good luck. I want to know where to download the song. Courtney, how do they download the song? I don't know. You've got version 3. I'm trying to even find where this is on Sono, right? Let's see. Were there other versions? Yes, possible Mr. Beast employee in the Airbnb. Possibly, I don't know. I'm not sure if this one is or if that's a different one. Anyway, we're trying to figure out what's wrong with my drive, because it's supposed to be hot swappable, and I plugged in the 2 gigabyte drive and it says not readable. So I need a cord, actually. Oh, I know what to do. I have a computer that can do that. It's a HyperDeck. Not sure if the HyperDeck setup will work, but nope. All right. Either way, we're going to we're about to start trial. Okay, Murray says it's with an AI and an E at the end. Sunday's my birthday. Sunday. Maraiki? Is that right? I'd say AI is I and the E at the end. Maraiki. I'm sorry if I'm butchering your name. I don't take it personally. I butcher everybody's names. I'm an equal opportunity butcher when it comes to names that way. Taminator61 gifted 5 memberships. Thank you, Tammy, for your generosity here. Let's see. I'm trying to. I just realized that what I just showed you. I unplugged the counter to get that view. Oh, and it looks like they're coming back here in just a second. So we'll let that play out. We have audio now. Or no audio yet, but it's all right. Okay, I've got to figure out. I've got to plug that in. Oh man, I wanted that plug to work, but it won't. Okay, so the counter is back. I'll figure out what to do with this right here. Oh, what a lunch. I had a sandwich and a couple hot dogs, actually. Had a couple hot dogs with some ketchup with dill flavor or pickle flavor, which was good. And then I actually had a snack of just dill pickles afterwards. Keith says, Yahoo, not Yahoo, but Yahoo. I made it 6 months. Thank you for being a part of my retirement plan. You're the best, especially when the missus joins in. Thank you. Keith, thank you very much. The missus is excited for me to join in the bathroom building, which needs to happen this weekend. We have to finish drywall, mud, tape, sand, paint, install flooring, and install fixtures all in one day. I don't know how it's going to work. We need like instant dry paint, apparently. Stephen Blevin says, 13 months. Is this bad luck? It might be, Stephen. Might. Hopefully this month passes quickly for you if it is. All right, Top Mark Media, it looks like we are done with the Chad Daybell case. Did it end early today on a Friday? Early Fridays? I want that schedule. If you want, you can drop the link for the song. You can. I will. I'll drop this out there. Let me... And by the way, thank you, Courtney. Let's see if this is the right one. Let's paste. If that's the right one. Okay, so let's go over here to our live stream. If you would like to check out this song on your own, I'm going to post the link to it if it will fit. I think it'll fit. There's the link to the song right here that Courtney made for us. It should have about 460 links and clicks in about a second. So that'll be good. Put the link in the description. That's even better. I'll do that now. After the say my name counter, there's the link. Save. Why do we see food? We're looking at the judge provides this as a reminder to those who forgot that it was lunchtime. So this is the splash screen the court provides for us at the end of when lunch has begun to remind us to go out and eat. Stephen Blevins just gifted 5 memberships as well. Thank you. Wonderful people, all of them who received those gifts. That was really kind. Appreciate that. Melissa Ann says, love being here. 8 months, Melissa. Thank you. Wonderful to have you here as well. Wonderful. All right, let's see. Where are we at? Mrs. Ari bought me, she bought 2 gallons of chocolate milk, and I think both of them are gone now. I only had 2 glasses, but the kids drank 2 gallons of milk in 10 minutes. And I helped. I know the court doesn't have food that looks that good. I'm not sure, Maddie. I'm not sure. This court actually gives all sorts of treats. They've got like special coffee makers, like the special K-cup or something machines just for the jury. They've got a whole bag full of treats, and these like, well, we restock them on request. I've never seen jurors treated quite like this before. It's like they're a frequent flyer club at the airport or something. KH in South Carolina says, glad to be home. Left Guam at 10 p.m. and got into Seattle at 7:30 p.m. That's a long flight. Wow. Unless you went back in time. Ashley, that is Courtney Meek's creation. I wrote the lyrics and she put together the song, and it was fantastic. It was really cool. What's the judge's name? I need to look him up and put a face to the voice. Let me show you if I can on the screen here just before court comes back. Oops. Let's see. Come on. Here we go. There's the judge's face right there on the screen. This is Judge Robert McBurney out of Georgia. Great guy. We love this judge. He's doing a good job and extremely patient. I don't know if he went to the school of handling pro se or not, but he's doing really well with that. So we're excited to see that continue. It's funny when he shuts down the pro se defendant. He's like, I object because I haven't had time to prepare my defense. And he's like, well, you made that choice, didn't you? Bummer. Next. It's so good. So good. Melissa Ann gifted a membership. Thank you, Melissa Ann. Thank you. Let's see. Kroger chocolate milk is the best. It's like dinner. It is dinner. He's firm but fair. I think so. He's doing a really good job. Let's see. Now that computer's done, I'm going to take this cord. Hopefully it didn't break anything. We're all still here? Yes? Do we have time to review the Canva update since yesterday? Give me just a moment. We'll take a peek at it if the judge takes a while longer. Let's plug in right here. Okay. Let's see. Canva from yesterday. Still have audio on from court, so we'll hear as soon as they go live. But this is the latest and greatest on the thumbnail. There's so much. There's so much here. We've got the cell phone towers, with the antennas, a hall pass. We've got the airplane because they had a flight. We've got the Airbnb Gone Wild trial. We have the menu up on the screen. We have the co-counsel for the pro se defendant, represented right here with a little bit of a deity, a certificate. Not sure which one that's for. We've got the DJ represented for rent. There was an Airbnb. We've got slime, YSL. We've got graffiti all over the place. Lots of slime. Peeking through the hands, as the witness said he did. We've got a full stop. Hello, my name is the new accused. We've got a robber who stole everything, including the gummies, wallets, phones, and all that. Look at the sneakers. Even got the sneakers. We have a snake, because that's what they do. They threw the phones when they left. The game they were playing at the party was Spin the Wheel of Fortune, and it was more like Misfortune. It said things like take a shot or take a layer. We have a get out of jail free or get out of something free token. I'm not sure Amber made that one. I forget what that one was for. We have the empty water bottle, signifying the empty water bottle that the attorney on the prosecution side had when he tried to get it refilled, but it wouldn't. Not sure what's on the roof right there. Let's see. We've got a camera over here in the corner, some swearing going on in the house, some language. The two girls who invaded the home and led the way for the attackers. I don't know. A basket of goodies, probably for the jury, and we have crab's legs and devil's lettuce and a ham sandwich and Boost something. And we've got a pickle. That's what we've got. Get out of jail free is immunity. There we go. Get out of jail free is the immunity. Thank you, Robert. Okay, I'm going to have to make a quick run to check to make sure my kids are not going to destroy the bathroom before I have a chance. Where did my camera go? Where's my camera? I've disappeared. Okay, hang on. Let me see if I can reappear. Inputs for 1 is 4. Okay, so the box is there, but give me a second. My camera's gone. Okay, we're back, but I have to run and check on the kids before they install something wrong upstairs, and that would be really bad for the bathroom because then I have to tear it out and do it again. Give me a minute. I'll be right back. Court might start while I'm gone, though. Entertain yourselves nicely. Be kind. I'm watching, always watching.
Is that correct?
Somebody just sent me a video of roaches fighting. I don't know who won.
Scratch all that. Oh, that was terrible. I apologize.
Have them send someone with more experience.
Don't miss the forest for the trees.
The zombie apocalypse may be upon us.
I was kicked back, taking it easy.
I'm not a camel.
Are we going to address subject matter jurisdiction?
When are we going to break for lunch, Judge?
Bring the jury.
Somebody just sent me a video of roaches fighting. I don't know who won.
I'm not a cat.
Don't miss the forest for the trees.
Mr. Butler, you've got your laptop back? Great, thank you.
Is that correct?
Okay, well, you got a few extra minutes because graduation took a little longer. Thank you.
I'm not a camel.
Investigator Maldonado, if you come back up here.
The zombie apocalypse may be upon us.
And Ms. Mignot, if you wouldn't mind, I think one of your exhibits, I think it's probably Kalish immunity letter. If you just grab that and put it with now that it's in and is not just part of the record, will be something the jurors can see. Let's just get that with evidence. Thank you.
All right, people are coming back in. Sorry, we're all good. Nothing is unrepairable.
All right, Ms. Rivers, are you ready? Great. Let's get back on the record, please, in State versus Pritchett and Robinson. We've finished our lunch break. Our jurors are ready to come back in. Investigator Maldonado is back on the stand. Mr. Hiles, anything from the state before we bring the jurors in?
So, one, I conveyed, I heeded your advice, I know what you were talking about. Mr. Abate was talking with Mr. Pritchett, conveyed the offer was still, was 20, but he had the ability to go non-negotiated if he wanted to. I guess technically everything's non-negotiated.
That's where we are now.
Yeah, so, but the offer would be 20 and it's up to Mr. Pritchett, or the recommendation, I should say, not the offer, recommendation would be 20, sir. And it's up to Mr. Pritchett as to how he wants to proceed.
Okay.
There's a deal on the
I'm just
table?
asking if you've got anything else.
There's a deal on the
I
table?
appreciate the update, and you can continue the update.
Yeah.
Okay, anything else other than that before we bring the jurors in?
No.
Okay. Ms. Mignot, anything on behalf of Mr. Robinson before the jurors come in?
No, Your
All right, Mr. Pritchett, can you share with me what, if anything, you spent time reviewing during the break? I don't mean the contents, hey, why this is that, but did you focus on statements or Instagram, or were you and Mr. Abate engaged in discussions because he represents the state and you represent yourself?
I tried to look over the phone records and in some interviews. None of the time was easy to say why, so I tried to switch through both.
Okay.
It was 12,000 pages of phone records.
It's a lot of phone records.
Yeah, I tried to skim through the best I could. I looked at some of the interviews.
Okay, so you had access to phone records and you had access to the interviews. And during the lunch break, you spent time at least skimming or perusing both those things. Okay, thank you. Anything else? All right, let's bring the jurors in, please.
All right, for the jurors.
Bringing our jury in. They're running out of ways to mix up their order.
Judge, President of the County Board.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back, jurors. I am curious, so far, what's been the best place for lunch for those of you who don't bring in your own food? So for future jurors, I can say, try this. And then I'm going to ask at the other end of the spectrum. What's been good?
Gusto.
Gusto. That's a place you can go to, or they had food here? Really? In what direction? Wow, you hoof it. You got like running shoes on? No? All right. And you ate there, or like on your way back, you're trying to get Gusto in you? Gusto wins. What would we put on the do not repeat list? Anything? I'm glad you haven't hit any place like that. All right, Gusto. I will share this with the lawyers and then answer the question. We still have Investigator Maldonado on the stand, and we are still in direct examination. I think you were going to dive into some Instagram records. So let's do that.
Yes. Just before the break, Investigator Maldonado stated that 31 was admitted into into evidence. All right. And do you remember reviewing the contents of Mr. Pritchett's Instagram?
I did.
Was there very much on there?
I can't recall the quantity.
I apologize, the Zoom bumped me out, so I'm having to reconnect.
Maybe it was telling you something.
So, opening PDF. And what is the target number? What's that changes?
Thank you, Selena.
What is the target number associated with this account?
Gifting 5.
With this account, the target number is 359-00698.
And what is the account identifier name?
Sure, this is the Rick_Rare account that I found.
And what is the registered email for this account?
Sure, it's imaxout with 2 X's 777@gmail.com.
And what does the vanity name show as?
Sure, it's Rick_Rare.
And is it this vanity name that you testified earlier to that can be changed whenever you wish?
Yes, it can.
However, the target number does not change regardless of what happens, correct?
That is correct.
And does the account holder have the ability to change the target number?
Not the target number.
If you don't establish a vanity name in Instagram, what shows up if I Insta someone? What is it? Or I gram them?
When you create a profile, you have to create a name.
You have to create a vanity name, or you create a name, or that's the name?
It has to be a name. So you can create like a header for the top of your page, but there is a name. Every profile has to have a name.
And that's the vanity? It's called vanity name?
Well, it's called an Instagram handle.
This says vanity name.
Well, the common usage of the term is Instagram handle.
Okay, but when Instagram pushes info out in response to a subpoena, they refer to it as a vanity name.
Correct. I guess Facebook or now Meta platforms, that's their terminology, but the common usage of the term is an Instagram handle.
Okay. Thank you.
Right. And what is the phone number associated with Mr. Pritchett's Instagram account?
Sure. With this account, it's stating 404-447-6440.
Stop sharing. I'm going to go back to the link media.
I don't think the judge uses Instagram very much, Don.
Okay. And do you see the image entitled profile picture?
I do.
Stop sharing again to display.
All right, here comes the music. Pretty sure we're going to have to trim this one down, or at least mute it. The Judge has never shown his camera.
Okay. On that image profile pic, labeled profile picture, do you recognize the person in that image?
I do.
And who would that person on the profile image be?
Defendant, Mr. Pritchett.
And is this in the Instagram account of Rick Rare?
It is.
Spend much time on those records anymore. I'm going to turn your attention. So, Officer O'Hare testified earlier that he was collected a cell phone off of Mr. Robinson, and he had turned that into the robbery unit. Was that a phone provided to you?
It was.
Okay, what type of cell phone was provided to you?
I believe it was an iPhone. I have to refer to get the exact make and model.
Okay.
Lots of whispering going on.
I've heard those things.
Your Honor, we're going to have an issue with 36.
36. I thought, okay, that's not 30.
So it's not on.
Not 32, it's 36.
Yes, this is
Okay.
Mr. Robinson's.
This is an extraction from?
Yes.
What would the problem be with that?
I don't know what that is.
It was turned over in discovery, and I showed them this morning.
Okay, I'm not interested in this morning. Turned over in discovery to Ms. Mignot, or in that first discovery that went to previous?
To Ms. Mignot.
Okay. So Ms. Mignot, I'm not quite sure what the basis of your objection is.
33 was shown to us. 36 was not.
Okay. Are you stating on the record as an officer of the court that the state did not provide to you the extraction from the cell phone that was taken from your client when he was arrested?
I think we have something we need to put on the record, and it has to be done outside of the presence of the jury.
Can you answer my question first? Are you stating on the record as an officer of the court that the state did not supply you with the extraction from the phone taken from your client when he was arrested?
Okay, so we have extractions for an Apple phone, Judge. However, whatever's on that 36, I have no clue what that is, because today we looked at 33.
The thing you're referring to as an extraction from an Apple phone, what makes you think that's different from state's 36?
Because I have not seen 36.
Well, but you have if it's the Apple phone. Are there extractions from any other Apple phones that the state provided in discovery?
Well, they had the two from Lauren and Kalish and Riley.
Yes.
And this is the third Apple iPhone extraction that was provided in discovery.
How many Apple phone extractions did you receive in discovery? Because if you received 3, then I'm going to accept Mr. Hiles's representation that this is number 3. I'm not really hung up on it's called Exhibit 36.
How we got it, Judge, we can't determine. We can't determine.
Riley and Riley.
Did the boom clear anything up about whether you've had, I'm not asking whether you reviewed it, but whether you've had through discovery the extraction from the phone that was allegedly with Mr. Robinson at the time he was arrested.
Okay, so on the discovery that we have iPhone dumps.
Sure.
Whether it's on 36, whether it's everything on 36, clueless.
Got it. All right. Your representation is that 36 contains, I don't like the word dump, extraction, the extraction from the phone that was taken from Mr. Robinson by Investigator O'Hare when he was arrested.
Yes. Okay.
And whatever that's called, you've shown Ms. Blake where it is in their discovery.
Yes.
That's the boom.
Yes.
Okay. Mr. Pritchett, do you have any objection to States 36? All right. I'm admitting States 36. That being said, during a break or over the weekend, I have no problem, Ms. Mignot, if you determine that there's something missing from it. As you know, this thumb drive has 1 zillion pages of information on it. The state is going to highlight a few. You may choose to highlight a few. That universe you've got and have had for a while, and you're free, as you have before. The state may go to page 112. You, if you choose to cross-examine this witness or use it with any other witness, can go to 212 because the whole universe is being admitted. Let's go forward.
I hear the judge just admit the whole universe. This case file's
So,
huge.
Investigator Maldonado, in doing so, in review of Mr. Robinson's cell phone extraction, did you see several screenshots of Instagram accounts that depicted Mr. Robinson himself?
I did.
Okay. And do all of those screenshots appear to be like, did they appear as if they were only his Instagram?
No.
So when you went through the photographs that were contained and screenshots contained inside Mr. Robinson's phone extraction, did you ever come across a photo of the warrants that you had actually taken out?
Yes, I did.
I'm going to share. Is this the photo that you came across inside of the phone dump of Mr. Tyrone Robinson?
It is.
Okay, and what is that a photo depicting?
Sure, is a Fulton County arrest warrant for Mr. Pritchett for the offense of aggravated assault with intent to rob.
He has to tip his head to the side, but he can still read it.
Sorry, I have to stop sharing every time. Now, did you come across a screenshot in Mr. Robinson's phone dump that appeared to be taken from the Instagram account of Rick Rare?
Yes.
Okay. Now, if you look at the top of the Instagram screenshot, what is the vanity name or handle associated with that?
Sure, this is going to be from Rick Rare's Instagram account.
Okay, and do you recognize any of the individuals that are contained in this photograph?
I do.
Okay, and who are those individuals?
Both defendants.
Okay, so if you tap the bottom of your screen, there should be a little stylus that appears.
Over to the left, there's a circle with a pencil in it that some people call a stylus. Now, if you draw on the screen, you'll make marks.
Did you want me to go ahead and indicate?
Yes. Would you as you circle the both defendants, each defendant you circle, please name them.
I put a PR for Pritchett here, and a TR for Mr. Trevor Robson.
And you can look. There should be a way to delete those.
It's a circle with a little arrow on it over on the left.
Okay.
If you tap it, each mark you make, you have to delete.
Gotcha. I'm looking just.
There's a bar on the left.
Here, sir.
No, along the left-hand side of the screen. Tap the screen again. There's a little bar come up with.
No, Judge.
Okay. You broke it.
You break it, you buy it.
Gently tap it just once. Nothing's coming up at all. Well,
I don't know. Maybe you can figure it out, Mr. Hiles. Why don't you go check out that screen? I can't reach over there.
That was posted 2 hours before.
There you go.
Okay, he can do it from there. Thank you.
All right, I apologize. I have to stop sharing for each picture.
Why do you get the feel that the defendant, the accused, is offended that they're saying that those shoes were stolen because of their color when it looks wrong? It's like, no, they were not yellow. They were green. Our colors are green, not yellow.
And do you recognize this to be a screenshot off of, or a picture that was contained inside of the phone number of Tyrone Robinson?
I do.
Okay. And did you notice anything significant in relation to this case about anything that he was wearing or articles on him?
Yes. So he has a lime green bandana that's draped around his neck, as well as some green socks. So both of these are representation of the Young Slime Life Gang, or YSL. They're a blood set, but they identify with green because it's the color of slime. If you think of Nickelodeon slime, for example.
Okay.
There it is, Nickelodeon slime.
And was that true of the picture that we just observed before this?
Yes, it was, with the green bandanas.
And at least through you, I think, was this Instagram, this phone extraction complete with pictures of similar nature with the slime green?
Yes, they were.
I don't think we need to go photo through photo this slow. So once you were able to get the phone dumps from Kalish, Riley, and Robinson, at which point, what did you do next in your investigation?
Sure. Once I got the phone dumps, I submitted them over to the district attorney's office and kept going through them.
Okay. At what point did you decide to take out arrest warrants in this case?
So the arrest warrants were taken out at the beginning of the stage of the case, once I'd identified who the individuals were, but I didn't stop my investigation there. I continued going forward with trying to go more into the case.
Okay. Now, what all did you base your arrest decision on for as it pertains to Max Pritchett?
Sure. For Mr. Pritchett, was able to identify him based off of the profile, which was supplied as the person who was present in the vehicle with Miss Riley and Miss Kalish.
Okay. And did you look to any conversations in the phone dumps of Riley and Kalish to enforce or assist with your decision to make?
I did.
Okay. And what specifically did you look at?
Sure. There were conversations on dates immediately following the robbery between Miss Riley and Miss Kalish, where they kept saying that they needed to reach out to Rick and Baby Slat about getting the proceeds, getting money, which I understood to be as the money that they were expecting to get from the robbery.
Okay. And did these conversations occur that you're referring to between Kalish and Riley? Did these conversations occur prior to you ever interviewing the two of them?
Yes, it was the days immediately after, the day kind of later in the day of the robbery, since it occurred around 2 a.m., followed by the next immediate day.
And did you document exactly what those conversations were in your report?
I did.
Okay. And do you recall some of the messages that you actually used to corroborate what they told you?
I would have to have that copy back again to tell you specifically, but yes.
Everything was the report that you had earlier.
There was one message between both Riley and Kalish where it was later on in the day. So we're talking almost 24 hours after the robbery, and it was actually 11:37, not 11:37 p.m. It was a.m. in which Miss Riley and Miss Kalish are saying that, so Baby Slat and Rick are still talking to me, so I guess that's good. Right? Basically, I guess they were anticipating that all communication would have ceased, but they're saying everything's fine because they're still talking after this incident.
And was there any communications between them trying to get proceeds from the two?
Yes, the two girls, Miss Riley and Miss Kalish, were constantly saying, well, we really need to reach out to them to get our money.
I want to ask you a question. We've looked at a bunch of records. I've noticed that some records say UTC time. What does that mean?
Sure. So it's going to be more of a universal time. So it's based off of Greenwich Mean Time, which is over in England. And so we are 4 hours behind. But when daylight savings is in effect, it's a difference of 5 hours.
Okay. Is that reversed?
For daylight savings time? Yes.
So when you're looking at the phone dump and some of the times say UTC -5, what would that mean?
Means that whatever time is indicated on there, to get to Eastern time, we would be the 5 hours difference.
So in the records, something says UTC -5. Does that mean as the records sit, it's already accounted for the difference between the actual UTC time and the current time?
Correct. Otherwise, it'd just be UTC. Just letting you know that it's factored in that difference.
And would it be, if it's actual UTC time, is it reflected either as UTC or sometimes is it reflected as UTC +0?
In both ways.
Now, the person that you have identified as, or the person you've been talking about as being involved in this case as Rick Rare and Max Pritchett, do you see him in court today?
I do.
Okay. Will you please stand up and identify him by an article of clothing and where he is sitting?
From where I'm standing, he is to my 2 o'clock position, if you will. He's seated at a standalone table wearing a black blazer. He's got kind of like medium twists that don't go past his ear, and he's a fair black.
And a matching ring too.
And please let the record reflect that the witness has identified defendant Pritchett?
He has.
And do you see the person that you have spoken of as being Baby Slat as well as Tyrone Robinson in court today?
I do.
Okay. And could you please identify him by where you're sitting in an article of clothing?
He's directly in front of me, seated at the defendant's table. He's wearing a gray suit.
Okay, that's not where we normally put the
He is seated in between counsel, and he has a small goatee.
Please let the record reflect that the witness has identified defendant Robinson.
He has.
Please let the witness sit down. Thank you.
And I want to go back to the phone dump of that was admitted Mr. Robinson briefly, and specifically going to the properties tab of the picture of that warrant that was taken or found in Mr. Robinson's phone. That picture of the warrant, does it, in the properties tab right there, does it indicate the day that that picture was taken?
It does.
Okay. And what would that date be?
It says December 4th of 2019.
Okay. And do you remember what date that Mr. Pritchett was arrested?
No, I'd have to back to the notes to get that date.
It's okay. It was previously. And was there anything else in your investigation that you used to make your decision to arrest any of the defendants in this case?
No, I believe everything has already been talked and testified about.
I don't have any questions.
Ms. Mignot, cross-examination of Investigator Maldonado.
Good afternoon.
Afternoon.
You testified on direct examination that the 1040 Wiley Street AirBnB was rented by Mr. Riggs for a party because the individuals that were supposed to be at the party had not seen each other for a period of time. Are you aware that most of the individuals at that party did not know each other?
No.
Okay. And if that was the case, that they didn't know each other, and it wasn't that they were getting together because they hadn't seen each other for quite some time, that would be misinformation for you, right?
Yes.
Were you also aware that the reason the party at the 1040 Wiley Street was planned was because it was a drug party?
I learned that through the course of my investigation, yes.
Did you also learn that Jackson had transported illegal drugs across state lines from California to Georgia for sale at the party?
I did not know.
Did you ever find that out as a part of your investigation?
I knew there were vast amounts of drugs. I just didn't know who supplied them.
Okay. And when did you find out that there was a vast amount of drugs there?
Through an interview later with Ms. Kalish.
Now, was that on November 16th of 2019 you found out the drugs were there, or prior to?
It was after.
And what, if any, actions did you take as a result of your knowledge that there was a vast amount of drugs at the 1040 Wiley Street location?
Well, that information kind of corroborated the information that was provided by the females that they went to obtain drugs.
Is the sale of drugs at that party illegal?
Yes.
Would it have occurred in Fulton County?
Yes.
Would it have been a crime in Fulton County?
Yes.
Would it have been a crime that you could have investigated and sought warrants for the arrest of individuals for?
I would have to have obtained the drugs.
You would have had to obtain the drugs?
Correct.
Okay, so would you have been able to get the photographs of the drugs that you were advised were present?
Yes.
And there were photographs of the drugs that were turned over to you as a part of this case, right?
Yes.
And you could use those photographs of the drugs and the information from either Ms. Riley or Ms. Kalish that those were the drugs that were present at the property on November the 8th of 2019, correct?
Yes.
And you could have used that to get warrants for the arrest of everyone who was at the party associated with those drugs, correct?
No.
You could not?
No.
Okay, and why couldn't you?
Sure, I wouldn't have any physical evidence to show the drugs, and they would actually have to show how the photograph was taken still within the confines of Fulton County to establish venue. And I don't think a judge would sign off from my experience in previous work in narcotics cases.
Would you have been able to do phone forensics just like the forensics you were just testifying from a few minutes ago?
Yes.
And those phone forensics you could have used to get warrants, correct?
Yes.
Okay. But you didn't do that in this case?
I did not.
In fact, you didn't arrest anyone for the illegal drugs and the illegal activity that occurred at the 1040 Wiley Street location, right?
I did not.
Now, you testified that Ms. Riley said that she didn't have her keys when you interrogated her on November the 16th of 2019, right?
Yes.
And she advised you that Ms. Riley had advised you that her phone was in her car and she needed to go to her car and charge her phone.
Yes.
And that she was not present when anyone entered the Wiley Street location to commit any acts of crimes in there, as it pertains to the robbery.
That is correct.
And you did not believe her, right?
That is correct.
And you continued your line of questioning with her to the point where you realized that she had provided a lot of false information to you.
Right.
Now let's talk about Lindsay's phone. Miss Riley never told you that Lindsay's phone was in the car, did she?
Not that I can recall.
Okay. So if there has been evidence in this case that the Lindsay's phone was the phone that was in the car, that would be inconsistent with the evidence you got from Miss Riley.
If that's accurate, yes.
When you had contact with Ms. Kalish, it was after Ms. Kalish had been in the interview room with Detective Burgess, correct?
That is correct.
And Detective Burgess is a female officer who had been speaking with Ms. Kalish while you were speaking with Ms. Riley.
That's
in
correct.
Two separate rooms. Now, as it pertains to Ms. Kalish's statement, when you initially spoke with her, she advised you that she doesn't know the names of anyone that was in the car with her.
Right.
And she also advised you that the two of them meaning Ms. Riley and Ms. Kalish, had gone to the party alone, right?
Correct.
And in fact, your investigation as it pertains to the footage of the Mercedes from the neighbor's surveillance camera only showed one female in the car, right?
Well, from the angle, you could only see the front passenger seat.
And you don't have any angles that you could see that there was more than one person in the car.
I would just assume there'd be a driver, but no, correct.
So you're assuming?
Correct. If the car is moving, I can only see the passenger seat. I would assume there'd be a driver.
Okay. But if you assume that there was a driver, you would have to assume that the driver was the owner of the vehicle, who was Miss Riley, right?
No.
You would assume it was someone else?
I'm saying I can't assume. I don't know at that point. I just know there's a driver. I just can't say who it would be.
Okay. And Miss Riley and Miss Kalish told you that Miss Riley was driving?
Correct.
And you don't have any evidence that anybody else drove that vehicle?
That's correct.
Did you do any investigation as it pertains to fingerprints or any type of forensics of the car to be able to place Mr. Robinson in the vehicle?
No, not specifically Ms. Robinson, no.
Okay. And as it pertains to any fingerprinting, did you do any fingerprinting that you could say, yep, that's Mr. Robinson's fingerprint. We found it in the backseat of the vehicle?
No, due to the length of time from the time I made contact with the car versus when the incident happened.
So the answer is no.
Correct.
Now, Ms. Riley and Ms. Kalish were consistent when they both said originally to you, when they first were questioned, that Ms. Riley went to the car and Ms. Kalish remained inside the party.
Yes.
But you all never believed that, correct?
Correct.
And there were times in your interview where you were arguing with Ms. Kalish that she was actually outside of the home while the robbery was taking place.
Correct.
But you were wrong, weren't you?
I was.
And she actually was inside the property when the robbery took place.
She was.
However, she advised you she was in the bathroom.
Correct.
So based on your investigation, Ms. Kalish would not have seen when any of the two male suspects came into the Wiley Street location.
Based on the statement she gave at that time, yes.
Okay. And she also stated that she left after the two suspects had left the property. She left the bathroom after the two suspects had left the property.
She stated that, yes.
Okay. So as far as your investigation is concerned, Ms. Kalish could not have seen anything as it pertains to the assailants coming in and going out, right?
Correct.
And Ms. Riley could not have seen anything as it pertains to the assailants going in and going out, because she was not inside the home at the time of the robbery, correct?
Right.
Now, you testified that at one point, both Sergeant Knapp, N-A-P-P, am I saying that correctly?
Yes.
And yourself were in the interview room and Miranda was read. Was that the interview room with Ms. Riley or with Ms. Kalish?
It was read to both.
Okay. And when you went into the interview room and read Miranda rights to Ms. Riley and Ms. Kalish, the subject of the questions you were asking them had not changed, correct?
Correct.
And in fact, some of the questions you had asked were being re-asked again after the Miranda was read.
Correct.
You also testified that the tone of the interview had changed. You also testified that the tone of the interview had changed. You remember that testimony?
Yes.
And in fact, although the tone of the interview may have changed, your suspicion of them being involved in the robbery had not changed, correct?
Correct.
And prior to you speaking with them, before reading them Miranda, you had had information from Miss Rebecca Mears that they were potential suspects, correct?
Right.
You also had information from Mr. Hooper that Kalish and Riley were potential suspects of the robbery, correct?
He just mentioned Miss Riley, but yes.
Okay. And you also had spoken to several of the party goers that evening that gave you information stating the Riley and Kalish, they called them the girls or the women, behaved suspiciously when they arrived to the party.
Right.
So you had several different sources that had pointed you in the direction of Riley and Kalish as suspects of a robbery on November 8th, right?
Correct.
Now, the video footage, all of the video footage that you were able to capture from the neighboring property, none of it shows two males exiting the Mercedes at issue in this case, correct?
Correct.
None of the video footage that you have show two males entering the Mercedes at issue, correct?
Correct.
Now, in part of your investigation, you actually appeared at the condo, or should I say the dorm, of Riley and Kalish. You went to their dorms, part of your investigation?
Yes.
And when you went to their dorms, you were able to find drugs similar to the drugs that were supposed to be at the party, right?
I can't say because we just labeled them as unknown items. They were sent for analysis for testing.
Is it your testimony that we are in, let me re-ask my question. You know now that they're drugs, correct?
I still actually haven't seen the final analysis.
Okay. So when you went to search Miss Riley's dorm, college dorm, correct? And this is at Life University?
Yes.
You found drugs in her apartment and turned them over for forensics, correct?
Correct.
And it's your testimony that we are now in 2024, and you as the lead investigator cannot tell these jurors if those drugs are an illegal substance or not.
Correct.
So if they are, that would be a crime.
Yes.
And it's a crime for which you could press charges against Miss Riley.
I cannot know.
You could seek a warrant.
I could not know.
You could not turn over the drugs if you found them at her property and the test results come back to show that it's either cocaine or some other type of illegal substance?
I don't have jurisdiction in Cobb County.
Okay. You could turn it over to the Cobb County Police Department, correct?
Yes.
And the Cobb County Police Department could pursue criminal charges for those illegal drugs found in their jurisdiction, correct?
Yes.
You did not do that, did you?
No.
Can you give us a sense, did you find kilograms of suspected drugs or little pill bottles or?
Sure, it was a couple of pills in a Tupperware container and then an unknown crystal substance.
But in terms of quantity, like a bucket of unknown crystal substance?
If it is an illegal substance, it'd be personal use, it wouldn't be anything more than that.
Is personal use legal if it's cocaine?
No.
Okay. In fact, if you have pills in a bottle other than a prescription bottle, that's a crime, correct?
Yes.
And you could have charged that crime or assisted the Cobb County Police Department with charging that crime.
Yes.
And you didn't do that.
No.
Now, none of the individuals that were alleged victims of the Wiley Street robbery could identify any of the two males that entered the property.
Correct. They said they all had masks on.
And descriptions varied from alleged victim to alleged victim, correct? And descriptions in terms of height varied.
Correct.
Now, the entry into the Wiley Street location was not a break-in, correct?
Correct.
Someone opened the door and walked in.
Correct.
Now, during your interrogation of Ms. Kalish, she advised you that she started changing her story. The person who was the second male, she really had not met before the night of November the 7th.
Correct. She said she had just recently met.
Okay. So how long have you been doing detective work?
Since 2018.
Okay. Now, in your role as a detective, it's not uncommon for someone to misidentify someone that they've only met or seen once, correct?
Right.
And she gave you, she meaning Miss Kalish, gave you the name in her interview of Slime, right?
Right.
Now, when you go on to Instagram, because you typed in Slime in your interview room with Miss Kalish, correct?
That was one of the things I typed in, yeah.
Okay. And during that research that you were doing on your cell phone, Sergeant Knapp was also in the room.
I can't remember at that point if he was or not.
Okay. Now, once you pulled up slime, isn't it true that that word pulls up thousands of individuals on Instagram because that's a popular word?
Correct.
And you had to somehow try to drill down to get Miss Kalish to identify someone by the name of Baby Slime.
Well, originally I was looking for slime, but yes.
Okay. And you were giving information to Miss Kalish to try to assist her with identifying who you believe was two males that committed an armed robbery on November 8th, correct?
Correct.
And in fact, this interview lasted approximately 4 hours or more, right?
It was lengthy, but I can't remember the exact amount of time.
Okay. Now, in your investigation, and I believe it's in your report in front of you, it would be page 207.
You don't need to look at it till you hear the question. You may not need to look at it.
Miss Riley was telling Miss Kalish in her text messages between Riley and Kalish that she deleted messages from the night of the robbery.
Yes, that's correct.
So, Detective Maldonado, we could have had, if we did, text messages from the actual assailants that entered the property that evening, but for the deletion, correct?
Correct.
And you don't have any information that it wasn't two other people other than these two people in these deleted text correspondence about the robbery.
Right.
And even the correspondence that we have in evidence that shows communication between Miss Riley and someone else, they don't mention the word robbery, do they, sir?
No.
In fact, they don't mention, I need my money from that robbery we committed a few days ago, and I need it now, right?
Not in that context.
Okay. In fact, it's talking about, hey, I need money to buy some crab legs.
Right.
And that's what you took and made a connection to, oh, she's talking to the person she told me was Baby Slack. And that must mean she's asking for money from the robbery that occurred November the 8th, 2019.
Yes.
Isn't that far reaching?
I don't believe so, no.
Wouldn't it be further reaching than it would be for you to have assisted Cobb County with arresting Miss Riley for the drugs in her dorm? It would have been harder to get her arrested for the drugs in the dorm?
The way I saw it is that robbery is a higher charge. By charging Miss Riley, the sentence would be much, more severe for robbery than it would be for simple possession.
Okay, so you prosecute based on the severity of the crime. So if it's not that severe, you don't really pursue that?
That's an argumentative question. Next question.
You didn't pursue the charges in Cobb, correct?
Correct.
And you could have.
Objection asked and answered.
We've covered this.
Now, the state showed you in its exhibit a target number associated with Instagram. Do you remember testifying regarding that?
Yes.
And the target number that is on the document that you read from this afternoon when we returned from lunch is not a phone number, correct?
Correct.
And it's not a phone number that connects to Mr. Robinson, correct?
It's a number just assigned from Facebook.
Okay. And the number that's assigned from Facebook can be created by an email address, correct?
No, the number assigned from Facebook is something that the company assigns.
So Facebook is assigning that?
Correct.
All right. So it's connected to an email when you set up, or it's connected to a phone number?
When the account is first opened, honestly, I probably couldn't tell you whether it's a phone number or an email, but it's assigned at the creation of the account to that, and it's linked throughout. So the name of the account could always change, but that particular account is always the same. Like that target number for that account stays the same.
Okay. So as it pertains to the target number, you don't have any evidence that that's an account belonging to Mr. Robinson, correct?
No, I believe I do.
You believe that's Mr. Robinson's account?
Correct.
Do you have any documents associated with proof that, hey, this is Mr. Robinson's account and this is his text message?
Directly where it states his name?
Yes.
No, I don't have that, no.
Okay. So you are now making the assertion that that's Mr. Robinson's account?
Yes.
Now, an Instagram handle can be changed, correct?
Correct.
And you found several profiles when you searched for slime.
Right.
And you kept searching until you got to a profile for baby slime.
Correct. I'd asked if Ms. Callish if there was, if she could remember more, and she said it was 11 something slat. And so that's when I started focusing on that as opposed to slime.
Okay. And in fact, when you do an 1100 search, that brings up a lot of Instagram accounts too, doesn't it?
It does.
Now, you showed an image in your interrogation video to Ms. Callish on your phone during that interview, during your November 16th, 2019 interview.
Yes.
And from the two angles of that video, we cannot see the screen of your phone, correct?
Correct.
So you could be showing her a picture of Mr. Robinson, but we would not be able to tell from looking at that video.
Could be, but it's not what I did.
Okay. But we can't tell whether.
Correct.
Okay. Now, you testified this morning that the name Tyrone Robinson came up by some investigation you did of an auto accident and picked up another name of Robinson and connected through the accident. This was an auto accident report.
Yes, that's correct.
And in fact, did you make a distinction with the Tyrone Jr. that was listed on the report?
I did.
Okay. And you are aware there's a Tyrone Sr.?
Yes.
Tyrone Robinson Jr. and Tyrone Robinson Sr.
The difference would be in the date of birth.
Okay. And did you do any investigation to determine if you had the right Tyrone Robinson?
Yes, I pulled up the driver's license photos for both and saw which one resembled the one in the Instagram profile and which one did not.
Okay. Did you show the driver's license information to either Callish or Riley?
No.
And this driver's license information you had pulled after you spoke with Callish and Riley on November the 16th, 2019?
Yes, it was later in the night.
Okay. Now, how old, based on your lookup of the driver's license, was Tyrone Robinson Jr.?
I would have to go back. I don't know.
Is it not in your report?
I put the date of birth on there.
Okay, could you look and let us know?
So the date of birth that I located was 9/10/1999 for Tyrone Robinson, and I only wrote the name of the one that fit the image when I pulled up the image.
So you found the date of birth for both?
Yes, but I only wrote the one of the person that matched in my notes.
Okay.
Which was junior or senior?
I didn't make that distinction in my case notes.
Okay.
Now, you did submit a subpoena to T-Mobile associated with the phone number that you thought connected to a Tyrone Robinson.
I believe so, yes.
Okay. Your Honor, may I approach the witness?
Yes, you always have the ability to approach witnesses.
Detective Maldonado, I'm showing you what's been marked for identification purposes. Defendants are, it's DR 18. Do you recognize DR 18?
Yes, I do.
And do you recognize it as a certified document associated with the T-Mobile searches that you did for the phone?
Yes.
Does it truly and accurately reflect the documents that you had received in a response regarding the subpoena?
Yes.
Your Honor, at this time, we'd like to tender DR 18.
Mr. Hiles, any objection to DR 18?
Yeah, it's not been properly authenticated. These aren't self-cert. There's no notice of self-authentication. Ronnie probably talking about it, but this is working notice of this.
Okay, Ms. Mignot, your response to whether you've laid a sufficient foundation for business records to come in.
I have, Your Honor, and also this is the discovery, just like the 10,000 or 20,000 pages that opposing counsel gave us. This came from the state.
Well, lots of things may have come from the state that aren't admissible at trial. Business records, if they're coming in, require a certification. I don't have DR 18 in front of me, but if there's a certification accompanying it, then you would have, it would be self-authenticating. If there's no certification that those records are regularly kept in the course of T-Mobile's business, this isn't a witness who can say that. You might have a T-Mobile witness up your sleeve. So to Mr. Hiles's point, absent that certification, I don't think it gets admitted, but it doesn't mean you can't ask the detective about things he acquired during the course of his investigation.
We'll do that, Judge. And if we get the certification, we'll revisit the issue.
We will do that.
All right, so as it pertains to—
I'm sorry, yes, Mr. Hiles?
My objection was that the certificate, this is a copy of the certification. There was just no notice given to the state about, you know.
It's something you provided though, so I'm underwhelmed by the notice argument.
No objection.
Okay, and again, I wasn't saying there wasn't a certification. I don't know what's in DR 18, but if that includes the certification, then you have laid a proper foundation. I overrule the notice objection, and DR 18 is in evidence. I don't know if it goes back with the jury, different question, but let's press on with Investigator Maldonado.
Thank you. Investigator Maldonado, you testified that the phone number 470-646-4757, you believe to be connected to a Tyrone Robinson, correct?
Correct.
And your investigation revealed that, in fact, in your investigation, you did subpoenas to receive call details and cell sites for that phone, correct?
Correct.
And in your investigation, you came upon information that shows you don't have any cell tower or data associated with that phone number, correct?
Correct.
So as it pertains to the Tyrone Robinson and the phone records, you don't have any evidence that that phone was connected to any particular tower?
Correct. T-Mobile said that they actually didn't have any records for that number.
Okay. Now, the state provided you with Instagram account information today regarding Mr. Robinson, Instagram. You remember those that we went over before we went to lunch?
Yes.
Now, someone could use their phone to set up an Instagram account, correct?
Correct.
Somebody could use their phone, their computer to set up an Instagram account.
Correct.
Somebody could use a tablet or any other electronic device to set up the account.
Correct.
And once the account is set up, if the person using a phone, a third person can use their phone and access another person's Instagram account if they have access to the passwords and the login information.
That's correct.
Just like my email, correct?
I can hear you over the door.
I apologize. No, just like an email.
Yes.
Okay. And in this case, you don't have any evidence that what we've looked at so far, professing to be an Instagram account information for Mr. Robinson, was accessed from someone else's phone, correct?
Correct.
And we know, because of the response T-Mobile gave you, that it's not accessed from Mr. Robinson's phone.
Well, T-Mobile just said that they're not the custodians for any record with that number.
So that means the Instagram information we looked at would have had to come from another phone or another device.
Well, the reason I got a subpoena instead of a search warrant was that it was material and relevant to confirm as well if that even was a good number. This was just a number that came across in my investigation. It wasn't necessarily one that I definitively said this number is associated with them. I was trying to find that information out.
Oh, so as you sit here today, is it your testimony that this phone number, you still don't know if it's even connected to Mr. Robinson?
Well, at least not through T-Mobile.
I'm sorry?
At least not through T-Mobile.
Okay.
So I'm confused. What are the last four? 4757? I'm not asking you any questions, Mr. Hiles.
Yeah. 4757 through T-Mobile, and T-Mobile said they're not the custodian of that.
How did the phone number ending in 4757 become interesting to you?
Sure. Can I go back to refer my notes?
You can refer and then look up and let us know. Mr. Hiles, this is not your space right now.
Mr. Hiles, stay in your lane.
So that number came from the extraction from the cell phone.
From the cell phone seized from Mr. Robinson.
Right.
In other words, that's the phone number for that phone.
Correct. Just it wasn't through T-Mobile.
Okay. So 4757 might be an AT&T service provider or a Verizon service provider. What the meaning of DR 18 is T-Mobile telling you that's not our phone. At the time you were asking, we weren't providing service.
Right.
Okay. I'm less confused. Back to you, Ms. Mignon.
Thank you, Your Honor. Detective Maldonado, you don't have any cell tower or cell sites location that connects Mr. Robinson to Wiley Street, correct?
That is correct.
And as it pertains to the Instagram, what we looked at in terms of the pictures or what's posted could be accessed by someone else, correct?
It could be.
Now, you testified that one of the things that you used to take out warrants for my client, Mr. Robinson, was the correspondence between Ms. Riley and Ms. Kalish.
That's
right?
correct.
Because that's your main source of believing Mr. Robinson is connected to Wiley Street robbery on November 8th, correct?
Yes.
And you used the conversation between them when they were talking about at least Rick and Baby Slat are still talking to us. You remember making that testimony?
Yes.
And you drew an inference from that statement, because that statement doesn't say anything about they're talking to us even though we robbed the place. Doesn't say anything about a robbery, correct?
Correct.
Doesn't say anything about money, correct?
That particular sentence, no.
But you used it to still connect it to the robbery, right?
Yes.
And isn't it true that the name Young Bands came up in your investigation?
Yes, it did.
And Young Bands is a well-known rap artist in Atlanta, at least, correct?
Correct.
And it's fair to say Young Bands is, I would say, rich?
I don't know. I couldn't say.
Okay. Has a record deal based on your investigation?
Yes.
And your investigation, based on the text communication you were looking at in the same chain where you saw, hey, at least Rick and Baby Slat are still talking to us. There was communication that said Young Bands blocked Riley, wasn't it?
I'm sorry, he did what?
There was text communication between Riley and Kalish that Young Bands had blocked Riley's phone number, blocked her.
Yes, that's correct.
blocking communication from her.
Right.
Isn't it true, based on your investigation, that young Bands blocked her because he realized what they had engaged in and he didn't want anything to do with those women's conduct?
It's possible. I can't speak as to why he blocked.
Okay. And it's not uncommon if you have an affiliate or somebody that knows of somebody that you're concerned, hey, they might not speak to me if that person's not speaking to me. It's not uncommon, correct?
Correct.
And you don't have any evidence that that's not what Riley and Kalish was talking about in that correspondence, correct?
Right.
You never sought a warrant for young Bands.
No.
And in fact, if you are to believe the statements you received from Riley, young Bands is one of the individuals who set up the robbery in the first place, correct?
Correct. He would have been present for the planning.
I'm sorry, I didn't
He would
mean.
have been present for that discussion planning phase.
Okay. And in fact, your investigation revealed that my client, Mr. Robinson, was not present for the conspiring of the robbery.
Right.
Detective Maldonado, isn't it true that the only reason you sought warrants from my client was based on what Riley and Kalish told you?
And what's in the cell phone, like the conversations. I use that as my totality.
Okay. And one of them would be, I need crab legs, right?
Right.
And one of them is, hey, at least Baby Slat and Rick are still talking to me.
That's one of them, yes.
Those are two things. And you took this information from two individuals, Riley and Kalish, that you know to be liars, right?
They were inconsistent statements, yes.
And they actually lied to you.
Yes.
And you even found more evidence that Riley and Kalish were at least considering robbing another drug dealer by the name Maddie.
I think it was just one. I can't remember if it was both, but just one of the two.
One of the two.
Riley.
Okay, Riley shared with you, hey, Lauren was thinking about robbing Maddie. He's a drug dealer.
Lauren and Riley are the same person.
I apologize. Kalish. I want to refer to them as last names since both their names start with L. Kalish told you that Riley was trying to set up a robbery of Maddie prior to the November 8th robbery.
Correct.
And that didn't have anything to do with my client, right?
No.
That's information you were gathering in your investigation.
Right.
And according to the information Kalish provided you, Kalish said, hey, that's a bad idea. That guy's got an arsenal. He's got a lot of guns.
That specifically, I don't remember that one.
Okay, you don't remember that conversation? But you do know that in your interrogation video, that Kalish said she didn't think it was a good idea. Do you recall that?
I believe so.
Okay. Yet you still sought warrants for my client based on your knowledge of what Riley and Kalish has been engaging in even prior to November 8th.
Yes, I did.
You never sought any charges for any additional crimes you were able to find after November 8th as it pertains to Riley or Kalish, correct?
Right.
No further questions, Judge.
Mr. Pritchett,
painful.
Accused, do you have questions for Investigator Maldonado?
Yes.
Let him get his thoughts together. See if they mirror the same ones that the other.
How are you doing today, sir?
Good, sir. How's your afternoon?
That's good. That's good.
I would say fasten your seatbelt, but you take all the time you want. There's no rush.
In your interview with Miss Riley, Do you remember at any moment did she state that she saw the individual that she knows as Rick and the other individual that she knew as Slime or Baby Slot? Did she state at any point that she saw those gentlemen with guns or masks?
So Ms. Riley didn't provide any names at first, but she said she didn't see anyone with a gun, and did not at that point of the robbery.
Okay. What about Ms. Callish? In her interview, did she at any point state to you that she saw a mask or guns? No. And you remember at the end of Ms. Callish's interview, her having an emotional phone call with her mother?
I do recall.
And you remember her stating to her mother also that she saw no mask or guns?
I don't recall the conversation between her and her mom. I remember allowing her the opportunity to talk, but I don't remember the contents of that.
Okay. Well, I'll go back to just when you and her were talking. In that second part, not the first part, but the second part of her interview, do you recall her specifically stating that even after the incident, she never saw any guns or masks in the car or wherever the next...
Hearsay.
How is it hearsay?
Talking about the conversation with her mother.
No, I'm talking about conversation.
No, this is back to, he said, let's just go back to when the two of you were talking.
Yes.
So repeat your question.
When the two of you were talking on the second interview where she took the opportunity, to tell you the truth, do you recall her stating that even after the incident, she never saw guns or masks?
That is correct.
You know Mr. O'Hare, correct?
I do.
What is he to you? What do you know him as? What does he do?
He is Investigator O'Hare. He is assigned to the Atlanta Police Fugitive Unit, and his unit goes and arrests people with outstanding warrants from major crimes units.
Okay. Do you remember the phone number that he provided you with for Pritchett?
I would have to refer to my notes to refresh my memory on the number, but he did provide me a number.
Can you go ahead and just refresh and let me know what that number says too, once you find it.
Can I read that number straight off? I won't remember the whole number.
Sure. If looking at that refreshes your recollection, share with us your refreshed recollection.
Okay. It's the number that he provided is 470-234-3324.
And you acquired search warrant for that phone?
For the phone number.
For the phone number. Can you, so you got the phone records though for that?
That is correct.
Okay.
When you're trying to get phone records, do you just send them to Verizon, T-Mobile, and see where it comes back, hence the T-Mobile strikeout?
Sure. So in 2019, we were using a system called Accurate, where you could type in a phone number and it would give you a presumed custodian of the number. Nowadays, in 2024, we can actually get the correct number, but there's been times where you would send it to a company and they say, we're not the custodian of this record, and then you would have to find which company it actually would belong to.
And when you say custodian, that would be the service provider.
Correct. The service provider who's the custodian of the phone records.
Okay.
When you require those phone records for that number,
I didn't follow the Kelly trail.
was there any evidence that it was connected to a tower near the location of 1040 Wiley Street?
No, there actually were no phone calls during that time period.
When going through that phone number and the phone records, were there any communication from that number to
the one that Brandy
Lauren
followed?
Riley?
I did follow that one. Sorry,
I would
Doc
have to
Lover.
go back and look. I don't have that offhand. I can't recall.
I was thinking
that's not
the other
you have in front of you.
gangster trial that ended in mistrial. That
Can you
Brandy
recall if there was
Churchill
any
followed.
conversations from that phone number to Lindsay Callish?
Ms. Callis said that she communicated via WhatsApp, not by phone.
To that phone number?
Not to that phone number, but communicated with who she said was Max Pritchett through WhatsApp, but not by phone. Not by cellular communications. Using a text message or a phone call, it was through a different type. WhatsApp is an internet-based communication. She said that's how she communicated with.
And you have those records?
I do not know.
That was so yesterday, future. I just don't remember. We won't know till Monday. Love your profile there, Petrified.
When going through the Instagram dump of the profile with the vanity name Rick Rare, did you find any communication from that profile to Lauren Riley's Instagram profile?
As far as messages go, I can't recall.
Did you find any communication from that profile to Lindsay Callish's?
I did not.
Now, according to your statements that you received from the victims of the incident, they were inconsistent, correct, or consistent?
As far as
the gunmen,
they were varying degrees of descriptions.
Okay. Do you remember any victims stating to you that they saw? Do you remember any other victims stating to you if they saw any tattoos on any of the gunmen?
Yes.
Which victim was that?
I'd have to go back to see exactly which one it was, but they said it was like on the shoulder. You know what I'm saying? That would be the victim, Mr. Kermode.
Okay. And he stated that the tattoo was observed on the upper left arm shoulder, correct?
Correct.
Okay.
So does he not have a tattoo?
According to your investigation and the footage that you have acquired regarding the incident, were there any footage or any evidence to show that two gunmen entered the Mercedes-Benz of Lauren Riley?
No, there was no footage of that.
Was there any footage of them leaving that Benz and entering the location 1040 Watts?
There is no footage of the gunman and the Mercedes together, but there is footage of the gunman entering the incident location.
Okay. Was there an investigation for the individual young band? Was there any questioning or anything that you acquired from him, or
No, I did
being
not
that
speak to young bands.
Okay. And why was that? I mean, his name was mentioned, just like other individuals' names were mentioned.
I don't have an answer for that.
Okay.
Would it have been someone else's decision other than your own to try to interview whoever you figured out young bands to be?
So the individual young bands was identified as Voss Coleman. He came up during my investigation. When I was talking to the district attorney's office, I was trying to see if we should, pursue that route, and it was decided not to pursue at that point in time.
Okay.
No further questions.
Mr. Hiles, do you have any redirect? We'll work through everyone's recross then as well. How long do you think your redirect will be?
Maybe 10, 15 minutes.
Okay. Do you all want a break? I see 2 times for a break right now, or assuming you've got questions for the investigator, during the time the lawyers and I are going through your questions, we could do your break then. Do you want to get through the remaining redirect, recross? Yes, is what I'm seeing. Okay, you'll make it. Mr. Hiles, let's get going.
Do you have where's the defense exhibit?
It's right in front of him.
Okay, please look to the back, second page of that. And what sort of records is that requesting?
Timing advance records.
Timing advance records. Are those different from call detail records?
Yes.
Okay, what is a timing advance record?
So a timing advance record, in a simplified version, basically it can give you a geographic location for a very small amount of period of time. It can be as little as every minute, it could be every couple of minutes, but essentially is a tracking of that phone wherever it was during the requested time frame.
Okay, so what that record shows is that there was no timing direct or timing advance records.
That's correct.
Okay. So I'm directing your attention to what's already been admitted as State's Exhibit 30 as T-Mobile records of Mr. Robinson for 470-646-4757. And do you recognize this business record authentication letter?
Can I see the whole thing? But
sorry, I was in the way. Is that better?
He's asking if you can see the whole thing.
Oh, I can.
So if you can scroll down.
And yes.
Okay, and this letter being accompanied with Okay, so is this when you send a search warrant for call detail records, is this the form that they were returned in?
Yes.
Okay, and was there in fact call detail records associated with Mr. Robinson's phone number that were returned?
Correct.
Okay, so the assertion that no records were returned from defense counsel is not correct.
Just no return of timing advance records.
Okay, that doesn't mean there's no records at all.
Correct.
So can call detail records, can those still tell you the consistent locations a person is making a call from.
Yes, the difference between the two is the timing is every so often it can be that very minute time frame, but call detail records have to rely on a phone call. So they only give you a location when a phone call is placed.
So I want to turn your attention now to the phone extraction of Mr. Robinson. Okay. And this is the bottom of page 1961. Will you please read what's been marked as column 44 and then the highlighted number?
Sure. It says com.apple.madrid, and it's making message that this is talking specifically to the application called iMessage. And it says Apple authentication process has been performed for the following Apple IDs. And then it provides two different numbers, one of which being that 4757 number.
Okay.
Roro, thank you. Congratulations on 7 months. It's been wonderful. And also thank you for gifting 5 memberships.
And this appear to be a text thread with the 4757 number inside of Mr. Robinson's extraction?
Yes, it does.
Is a separate text thread inside of Mr. Robinson's extraction with the 4757 number that you have associated with that?
Yes.
A separate iMessage in I guess, thread with the number ending in 4757 from the iPhone extraction of Mr. Robinson.
It is.
Is an additional?
It is.
It's an additional iPhone conversation through the phone taken off of Mr. Robinson with the number ending in 4757.
It is.
Okay. I want to go to a few other, just going to keep scrolling through. I want to go back to.
I've driven by many a bar, if that counts.
Okay. So, inside of Mr. Robinson's extraction, this is the page number 448 of his phone dump. And column 79 on 448, what does it say that it got this source from?
It says this came from Instagram.
Okay. And is the GOAT 1100 another Instagram handle that was present inside of Mr. Robinson's Instagram dump?
Yes, it was.
Okay. Will you please read the target number associated with Mr. Robinson's, with the GOAT 1100?
Sure. It's 307-640912.
Okay. And in that message, what does the first message on the screen say?
They're sending that phone number.
Okay. And who does it say that that phone number is sent from?
From the person whose Instagram is the GOAT 1100.
Okay. I'm going to stop this here. And I'm going to go to Mr. Robinson's Instagram dump. All right. Please read the target number for the account 1100 baby fight.
Yes, it's 307-640912.
Okay. And is that the same target number from the phone dump that we were just looking at Instagram messages and the phone extraction of Mr. Tyrone Robinson?
Yes, it is.
Okay. And can you please tell me what the registered email address is associated with Tyrone Robinson's Instagram account, 1100 Baby Slap?
It is Robinson Tyrone 999@gmail.com.
Okay. And at the time that these Instagram records were returned, can you please tell me what the vanity name associated with Mr. Robinson's account was?
It'd be _the goat 1100.
Okay, I'm going to stop this here. Please tell me the sender's name in this message.
Sure, it'd be the Instagram account, the goat _the goat 1100.
One of the defendants is proceeding.
ID number?
It is the 307-640912.
And what is the phone number sent in that message?
It is the T-Mobile number ending in 4757.
Keep mentioning the goat.
What's that?
Viola, welcome to the gallery.
Sure. So it's an end-to-end encrypted service. Basically, messages aren't stored like they would be for a text message. You have to have both ends of the device, hence end-to-end. So if I'm sending you a message on WhatsApp, no one else can see that message unless they have one of our phones. But we can also delete it, and when it's deleted, it's gone.
So if one person deletes that message, is it gone?
From that device, but it also can be deleted for everyone. They have a feature where you can delete just on your end, or you can delete it for both sides.
Okay, so one party with a WhatsApp communication device could delete a conversation from both devices?
Correct.
Okay. All right, no further questions.
Ms. Mignot, do you have any recross of Investigator Maldonado?
Yes, Your Honor.
Your turn.
Starting with defendants R18 in front of you. You requested call details with cell sites, correct?
Correct.
And you got no cell sites back, placing Mr. Robinson's phone at Wiley Street, correct?
Correct.
As it pertains to the numbers council just went through, let's talk about the text thread. The text thread on page 448, which professes to be from Mr. Robinson's phone, it does not show any information about a robbery, correct?
Correct.
It doesn't show any information about Wiley Street, correct?
Correct.
It doesn't show any information about money stolen, correct?
Correct.
Doesn't show any information about drugs stolen, correct?
Correct.
Isn't it true that Ms. Riley never said anything about the GOAT 1100?
That's correct.
Never came up.
Correct.
And Ms. Kalish never said anything to you in your investigation about the GOAT 1100.
Correct.
Counsel pointed your direction to a Robinson Tyrone 999@gmail.com. You remember looking at that just a few seconds ago?
Yes.
You had 2 Tyrone Robinsons that you located in your investigation, correct?
Correct.
You don't know which one of them this email address belongs to, correct?
That's correct.
There is no registered phone number associated with the data we just went over, correct?
With cell phone records? Or
Yes, yes.
But there is, the cell phone records are for that one number.
The 4757 number we were talking about.
Right.
Same one depicted in DR 18.
Correct.
All right. And as it pertains to your testimony, you said WhatsApp can be deleted on both ends by one person.
Right.
And the only person you had that deleted stuff based on your investigation was Lauren and Riley, right?
Correct.
Nothing further.
And to the accused, any follow-up?
Say my name. What's my
In your
name?
phone
What's my name?
extraction for the phone records of Mr. Pritchett, that number, which was from O'Hare 470-234-3324. Did you see the WhatsApp messages any WhatsApp messages from that phone to Lauren Riley or Lizzie Callis?
No, because they're two separate. WhatsApp is different from the actual cell phone records held by the provider.
Okay. Jurors, if you have questions for Investigator Maldonado, let's get those to Deputy Gordon, and then we will start your afternoon break.
At which time I will wander out to the fridge and find the last remaining Mountain Dew and consume it.
Thank you, sir. You all should head on into the jury room, the hallway, whatever you need for the break, and we'll see you in a little bit. Please don't talk about the case. No outside research.
There goes our jurors. Nobody wearing any gang colors, I think. 4, 5, 6, 7. I'm a little bit frustrated. My Samsung 2 terabyte drive is not reading properly. Done everything I can. It won't let me format it.
Ms. Mignot, would you have any objection if I bifurcated this trial and what went to the jury first was everything except for count 18, which is participation in criminal street gang activity, and we see what the result of those deliberations are, and then see what the state wants to do depending on the outcome of their deliberations on everything except for count 18.
Can I discuss?
You should. I just want to lay that out there. You don't need to answer affirmatively right now, but think about that.
Yes, sir.
Put some thought into it.
You need an answer before I leave today, Judge?
Probably not because, well, it depends. There goes the hand slapping. I don't know who the state's next witness is, but we will get through this witness and want to start the next witness. Who is your next witness?
I have 2 witnesses left in the trial. I've got Velasquez, who is 418 just towards Mr. Pritchett, and then JP Miller.
Okay, so they're both gang related, because if we're bifurcating, then we wouldn't get into Velasquez. That would be something that would come in phase 2 of the trial, along with Miller, which is the PowerPoint and the videos that are the other part of the 418. So what I'll call the Robinson half of the 418. So I guess we would need to cross that bridge before the next witness is called, because if Velasquez starts testifying, then we're into the core of the state's case in which they seek to connect the 2 defendants to gang activity. I know there's been some peripheral green handkerchief and the color of the shoes and everything, but one way to get a partial verdict would be to send this to the jury minus count 18 and all the baggage that comes with it, the 418 rulings, this PowerPoint, et cetera. So you can say, Judge, I don't even want to answer that question. During the break, you and Ms. Blake and Mr. Robinson should think about it. I need to get these questions to you first, so let me finish numbering them. All right. Let me read them, and then I'll hand them over.
Did you want me to come up
In a minute, because we're also taking a break. In fact, if you all need to take a break, why don't you do that now, including Ms. Rivers? I'll read through these. We'll come back from the break a little bit early, so let's keep it 5, 6-ish minutes, and we'll go over these and then bring the jurors in. Okay, so I'll mute the microphone and let's.
He muted it right away. When he says he's going to mute the microphone, he's done. All right, let's see where we are. Let me show you a quick little what my dilemma is. See in the bottom, well, I need to get rid of the say my name thing. Well, I can do that over here. There we go. Oh, that wasn't it. It's this one. Okay, the bottom left-hand corner, see where it says disk error? Doesn't work. Switch it to the other drive. Also doesn't work. So the cloud dock is not taking any data right now, which is no bueno. No bueno. So we've got to figure out what's wrong. I think I need to buy a cable, believe it or not. serial ATA to USB, probably USB-A cable. So I can externally format this again and see if that might fix it. Second issue is my Cloud Dock itself is not playing nicely. It does not want to let me connect to it. So apparently there's a password on it, which I have not set up, but it's brand new out of the box. So, we'll see. That's where we are. And my network now doesn't. Man, nothing's playing nice. Nothing's playing nice. Look at the troubleshooting guide. That's what I've been reading this whole time. That's why I'm not paying attention to anything. Trying to fix this. All right. What's strange about that, Ivan? Mark, that's the one. You're literally holding the one I need. I think they're like $8 on Amazon, so I'm going to grab one. Is there a particular brand, Mark, that... I'm choosing it based on the time they will arrive. So USB 3.0. Let me get a USB-C. That'll work better with my different devices. Do I need it in red? Yeah, I need it in fire engine red. Oh, and it'll arrive tomorrow. Yay! Wait. Does C arrive tomorrow? Only A arrives tomorrow. Hey, guess what we have, guys? Listen. Hello? 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 Dang it. Maybe they'll call back. All right. Let's see. We're in break right now. This trial has moved along. It started going a little bit slower here, but we're actually right near the end of the state's case. And quite honestly, the connection between the defendants and the crime is sort of weak. If you look at this, the connection is only through two people who are also charged with this crime and who have both admitted to lying to either the police or under oath or something to that effect. Yeah, about that. There is some evidence, but as far as actual physical evidence, there's not a lot there. There's not a lot to link these two there. And I wonder if the defense can push hard enough and break that link or cause some doubt in the eyes of the jury, then we'll see. I didn't follow the bifurcation as much. I think he wants to separate out the gang affiliation part. Not sure about that. It's a who's lying less trial. I will say that the accused has done a good job of not implicating himself in his questioning of witnesses. He's been very cautious there. Okay, we're going to do this. Get it tomorrow if I order it right this second. And it's a business expense. Tax write-off. Place your order. There we go. Hope that was the right one. Yep, I think we're good. All right, so we'll get that fixed tomorrow. What about the girls going to the guy's apartment where the drugs were on the bed? It's still just them. It's still their testimony that links that up. Don't think the defense attorney should have focused on asking why they didn't arrest the boys for the pictures of the edibles. I believe she should go harder on the lack of evidence. Right. The whole, hey, why did you arrest my client and not the other guys? That's not a good argument for me. It doesn't resonate as much. Just like, because your client was the one with the gun and kicking people's heads. That's why we arrested your client instead of the guy who was chewing on a nerd rope. You know, when I weighed everything, all the options available to me, I thought, let's see, candy nerds with some THC or violent felon. And I went with the violent felon. I hope he really has time to put it together. I think he's going to have some regrets. I think he's going to have some regrets and second thoughts afterwards, and things he wish he had said or wish he had asked or stated. Who was more dangerous? I think it's funny when they tried to chase that same rabbit with the girls and the crimes that they committed. And they're like, why didn't you arrest them? And he's like, because I couldn't. Because I didn't have enough for warrants. No regrets, right? Some regrets. Some regrets. We have all, for those that are new here this afternoon, we have had a little bit of a little Gang 101 lesson this morning. If you missed that, you need to go back and watch it because there is a test. But we learned all about YSL, about the colors and the signs, and we know why just wiping your nose now is enough to get you shot in the wrong neighborhood. So that was fun, and we got so excited and enthralled in the world of gangs and the music industry, which especially rap-wise, seems to be interwoven with the two, that we went out and started our own little fictional gang. And me, I took on the name Big Dill. I am the Big Dill. I wrote my first rap song. Courtney Meek has already run down to the studio and mixed it up together in an amazing version that you'll probably hear on the radio soon. Quite honestly, it's that good. So we have that. If you want to be a part of the gang, like and subscribe. What should our what should our threshold be for admittance? Evie says, I don't think it's fictional to us. Yes, we already know that some members, I'm not going to say who, are already getting tattoos to celebrate. Let me just give you a little taste of the music. Oh, first we got a call. Hang on. Ivan, what's up?
Prospecting member.
Ivan, what's up?
Well, I'm just wondering, like, you know, this is taking on a life of its own already. You know, once you go down this path.
I'm pretty sure the feds are already crawling all over my phones. I'm thinking I pretty much am on the no-fly list now.
Blood in, blood out, man. That's what they say.
We've got to get some merch lined up. Obviously in our colors, you know, so we can fly our flag, so to speak.
Right. Well,
did you hear our
I'm
song?
just thinking. Oh yeah.
Yeah,
Did I hear it?
It's thumping.
I think initiation should be a full jar of spicy maple bourbon pickle juice. You got to chug one of those.
Drink the juice and eat the pepper. I'm thinking you got to eat the pepper at the end.
That's good initiation.
It's not going to be easy. Not just anybody can join.
You can't be just willy-nilly with your memberships. You got to have some kind of bond of loyalty to prove their value. But well, what? So you like your new toy, huh?
I'd like it better if it were working. I'm a little frustrated. I spent a lot of time on the forums. That's when I was looking over here. I was either reading the forums, installing new firmware, flashing the firmware on here, reading Reddit forums about this. I'm a little frustrated. I thought they pretty much described it as plug and play, and even though I'm well beyond that as far as my capabilities, it's not. And
have you tried plugging it in?
Over and over. It did not come with a power cord. But luckily, I've saved every power cord for every device I've ever owned, and I was able to just run upstairs and grab the right one. But
yeah, my dad still has a VCR manual from the 80s. Okay,
one day that'll come in useful. Those are good things. Keep them around.
All right. Well, I just wanted to make sure this new life you've chosen hasn't changed you too much. Don't forget your roots, man.
Oh, it's I'm drawing from my roots for inspiration for my next album. So remembering where I came from.
I'm expecting a metal detector rap soon. You can't just go to sleep after one hit. A lot of these guys.
I've already, been very much made aware of the fact that I forgot to include cockroaches in the song, metal detecting. There's a few things that just tech in general needs to be represented a little bit more. Buttons.
Well, I did a little Wikipedia search of young bands. Turns out he does have some, certainly nothing any of us probably know, but according to Wikipedia, which we all know is the gospel of information, back in 2017, he had a certified gold single.
Yeah, 500,000 sales.
Well, that got a little skewed since the download era.
So it's Spotify, but still, that's a lot.
But 7 years ago, if you only got one hit 7 years ago, and hit is being very liberal with the term, let's just say, no wonder you're selling drugs to college kids. People, I can't imagine anybody who's successful is doing that just because they want to. I sure hope not.
I think it's part of the life, but Ivan, we're going to start here in just a minute. I'm going to let you go.
All right, sir.
We'll see you. All right, bye.
Yep, bye. Love you guys.
I was gonna play a little bit of the music as we're waiting to get back for court. Judge, can we play it just a tiny bit as they read the questions?
Wake up in the morning wearing headphones. I'm running court into your brain like it's an ants on my money's green like the pickles. And you want some go interrupt, cause I don't want your lame objection. From lettuce to the murder, like I think I've seen it all. From picking out trees to the moment the game of balls. The judge takes the bench and the bells all rise and pay respect to the one and only go to true crime. I'm ready to say it's they tried, but they just can't cheat. And when they fail, they be like, ow, I stepped on a beat. They take the stand and the jury choose not to believe, because there will never be another creator like me.
All right. We're gonna tune that one down because court's in session, so we can't play the whole thing. Man, that one thumps. Courtney, that is amazing. That just thumps. Wait, how did you get the singing? This is the part I missed. Tisha, yes, you missed the song. We've got the track. We are going to drop it on LP, so all the DJs can spin it up at the club. We're going to be doing that.
Thank you.
You need the lyrics. The lyrics are on page 4 of the thumbnail.
I'm going to go by the numbers here. Questions on card 65. First is, why didn't you search young band's home? Not a problem there. Then there are a couple questions about gangs. How do you become an official member? And this and that. I don't think there are appropriate questions for this witness. And so my thought is to save them for the next witness or the witness after. Do you have any objection to that, Mr. Hiles?
No.
Ms. Mignot?
Is that number 66, Judge?
No, card 65 has 4 questions.
Oh, okay.
The first is, why didn't you search young Van's home? I'm going to ask that. The second and third are, how do you become an official member? Do some kids wear gang colors just hoping to be part? I don't think this is the right witness for that. He's not qualified as a gang expert, and there is a witness with whom we can explore that if we're not bifurcating. And so my proposal is to not ask the middle 2 questions. The fourth question says, what was time period defendant from baby slat to the goat? I think I understand what they're getting at, and I think the detective can talk about from the records, here's baby slat, here's the goat 1100. But the middle 2, I don't intend to ask. Any objection?
No objection.
And Mr. Pritchett, no objection? Okay. There's card 67 is all about searching through Instagram to try to find direct messages and whatnot. I will ask those. 66 is a question about the second, I don't know if it's a ring camera, surveillance camera in the neighborhood showing when the car was going around. I will ask that. Card 64 is almost stream of consciousness. It says linked media, dated, there's a date, which is later than the incident. Why? Preservations 1 and 2, and there's a date. Why? And then I think the substantive question, which is, does that mean a lot of things could be deleted before the preservation date? I'm not sure what the linked media dated February 8th, 2024 is all about. I'm gonna start with you, Mr. Hiles. Does that mean something to you?
So sometimes it'll just like the date of the file transfer it's not like when we get linked media, the date we get the file transfer, that'll be the title of it. And then the actual date it was linked is like.
So I'm not aware of any extractions, info from Instagram or anything coming as late in the game as February 2024.
So that's like when if it was copied to a disk or like copied like in preparation for trial, it'll show like, all right, it's copied on like this date, and then you go into the link.
I understand that, but so am I correct that there wasn't evidence acquired from a service provider or out of a phone in February of last year?
No, but I take all this stuff, and when I put it in the trial or put it in the record, I take it and copy it onto.
I get it, and that's going to show up in your last trial. There was lots of debates about, couldn't this date change? Okay, I'm going to ask the witness about when things were acquired, and then we'll go from there. Does that work for you, Ms. Mignot?
Works for me, Judge.
All right, Mr. Pritchett? Okay. And then we're to young bands. I think it's question 63 is why wasn't he looked into further? That's appropriate, and I'm going to ask that. 62 is a little more complicated. You stated the DA instructed you or the investigative team not to pursue young bands. What was the reasoning given by the DA's office? Technically hearsay, but if you don't object to it, Ms. Mignot or Mr. Pritchett, it's out there now. You were very appropriately exploring, why don't you do something with this guy? And the answer was, I was told, my words, not Maldonado's, I was told to tap the brakes by the DA's office. Do you have any issue with Maldonado, sharing what he recalls the discussion to be?
No, Your Honor, no objection.
Okay, Mr. Pritchett, your concerns about that, Mr. Hiles? Okay, then that's what I'll cover with the jurors. We'll bring them in a moment. I just want to I know this was short notice, but I want us to talk about how we're going forward. The next 2 witnesses all relate to the gang activity count 18. In particular, Miller, who's going to dive deep into that. That's where the videos would come in. The other witness gets into Mr. Pritchett's prior home invasion conviction. And I'm wondering if you had a chance. I know you had a chance, and it's not much of a chance. And so I wasn't trying to jam you up. I didn't have the idea until the middle of Maldonado's testimony that, wait a minute, I may be able to control how this flows. I think I can over objection, but I don't want to do certain things over objection. What are your thoughts about bifurcation?
I've spoken to my client, Your Honor, and he wants to accept the bifurcation.
Okay. Mr. Pritchett, I didn't engage you on this initially because I wanted to let Mr. Robinson, his lawyer, work through it. If I were to, I don't know that I will, but if I were to bifurcate this trial, what would go to the jury first would be all the counts of the indictment, except anything I grant a directed verdict on, which we deal with later, and the one gang count. And that would mean that the jury right now would not hear from the gang expert. They wouldn't see that PowerPoint that we've spent a lot of time talking about. They wouldn't watch the 2 videos with Mr. Robinson in them, and they wouldn't hear about your prior home invasion because the state is getting that in per my ruling through its alleged connection to gang activity. They wouldn't hear about it now. They'd issue a verdict. Regardless of that verdict, the state would still be able to go forward with the gang count and present those 2 witnesses and anything else they wanted to present that they'd given everyone notice of. But they might not, depending on the verdict. If the jury finds you guilty of a bunch of the serious offenses, the state may say, you know what, we're going to dismiss that. That's their call. They're going to make that decision. But the first set of deliberations would be, did the state meet its burden on home invasion, armed robbery, aggravated assault, and aggravated battery, and not the gang piece? And what Ms. Mignot has said is that she doesn't oppose this bifurcation. You haven't had a whole lot of time to think about it. You don't get to consult with anyone. Do you have a reaction to that notion?
So if there is no opposing force for me, how does this deal? Like, what's the next process? And like, what they call what a different witness they have? Or
So I'm not sure I follow. Let me give you the 2 scenarios, and then you can ask your question again. If I decide to bifurcate and say, let's just hold off on the gang count, then I think the state's done. I don't decide that for them, but the 2 witnesses they've told me they have left only relate to that count. And so what would happen then would be that Mr. Hiles would say the state rests. I'm gonna send the jury home. We've got lots to talk about because the state rests. But they wouldn't have any more witnesses at this point because I'm saying, let's deal with the gang charge after the jury decides what it's gonna do with all the other charges. If I don't bifurcate or Mr. Hiles convinces me that I shouldn't or can't, maybe legally I can't, then the next witness is going to either be the detective who's going to talk about your other home invasion or the gang expert. Those are the 2 that the state have said are left. And we'd hear that, and the jury would be deliberating on all the stuff, armed robbery, this, that, whatever, and the gang count. So that's the difference.
Okay, so I don't oppose that.
The bifurcation? Okay. Mr. Hiles, I know you've got passionate thoughts about this. Why don't you share with me your thoughts about bifurcation?
Well, start with, in my opening statements, relying on the 418, I told the jury that 1, they would hear the other acts as to why Mr. Pritchett left his phone in the car. I also told them that
so he didn't leave his phone in the car. He left his phone in the apartment.
He did not bring his phone.
Mm-hmm.
I laid that out specifically, and I told them that they would hear about it.
Okay.
I just got an email. Yeah. So
Mr. Armstrong's weighing in.
Somebody.
Chris, thank you very much for the membership. Appreciate it.
So that's one. I think it's unfair because I've already promised something that they would not hear. And if this would have been bifurcated at the beginning.
If I had thought of it in the beginning, then you wouldn't have said that in the opening. I appreciate that.
And I could have, and if you've done it like, I could have filed 4 to 4 essentially, because that would I think be admissible under 404B, but I didn't think it was appropriate because
which would have been admissible.
The prior act as the motive.
Okay. All right. We don't have to litigate that now.
But also too, the gang evidence shouldn't be excluded because it is also motive and goes to intent to commit the crime. I intentionally withheld a lot of the information on that phone dump through Maldonado that I would have brought out had I known that this was even going to be potential.
What's an example?
So it is the
And whose phone?
Mr. Robinson, the only one that's in evidence. There is no phone in there.
Okay.
Yeah. So it is showing evidence. I showed a couple pictures, but evidence that Mr. Pritchett and Mr. Robinson were together consistently, wearing the gang colors with other gang members. And it's more than just two photos, not something that shows that they're just.
But them being together wearing the gang colors would be evidence of the count that nothing's being excluded, it's being deferred. It would be, sure, if we end up getting to the gang count, that could all be shared. But them wearing the gang colors doesn't advance, were they the people who were the home invaders?
So, but it does, it goes to motive, and it's essentially, it's intrinsic evidence and evidence to motive. I told the jury at the very beginning too that this was a gang motivated crime. It was motivated by gangs, greed, and lust. And I think I'm being undercut here from fulfilling what I was told, what I told the jury I would be showing. I would not have said that. I would not have said any of that. And it's only two more witnesses. And
yeah, but with this group, that's a day. We're crushing this jury.
Soundbite.
So I would also cite two cases why it would be inappropriate. It would be one, Middlebrook v. State, 310 GA 748, as well as England v. State, 302 GA 333.
Okay, I know right now you are way out ahead of yourself with those cases. Any idea what they say other than that an appellate person said, throw these numbers at the judge? I'll be looking at them right now too, but.
The judge, you're way out ahead of yourself with those cases. You have no clue what's in those cases.
Exclusion and bifurcation is not proper because it goes, even if the gang charge wasn't charged, this would be proper evidence as to motive. And intent.
You rely pretty heavily on motive. You are suggesting that Mr. Pritchett's prior home invasion would come in for motive?
No, but it could come in to show plan or course of conduct, especially when.
Did he wear either a monkey mask or a purge mask or he just sit in the car for the other home invasion?
No, but what's key about the other home invasion is the importance and the reliance on cell phone data to.
But that's nothing to do with motive.
But it has to do with plan.
Okay. They used this. Okay.
So I would close. So,
Ms. Green, if you've got it, you're welcome to chime in. I don't know if you've read them.
I'm just facilitating.
So Bullard v. Bullard v. State.
So Middlebrooks. Middlebrooks doesn't talk about bifurcation at all. Send that one back to the appellate section.
Bullard.
Middlebrooks is a great gang case for the state, but it's not.
So, Bullard v. State, 307 GA 482, 2019.
Can you give me the site again, please?
307 GA 482, 2019.
Thank you. Does that deal with bifurcation?
It does.
Okay, that'll be the first of the citations you provided that deals with bifurcation.
So at 489, it says, generally speaking, bifurcation of trial on the grounds that evidence admitted to prove one charge or prejudice the jury in its consideration of other charges is unnecessary if such evidence is legally material to and independently admissible as proof of those other charges. This bifurcation was not necessary here if evidence of Bullard's gang affiliation would have been admissible in separate trials. So
he's reading the summary. He's reading a summary, and the judge is going to read the case.
Under 418, it comes in as propensity evidence.
I get it. If there's a gang charge.
You guys have been hard at work in the studio. You think I've been sitting here, but I've actually been remixing the song. Took it down a notch, cranked the vocals a bit so it's a little more clear. I'm not sure if you guys want to listen to the judge argue this one out with the prosecutor, or if you want to hear the latest
307
drop.
Georgia 482.
All righty. Song. Judge, says Brittany. Judge. Check phone, please.
So you're feeling like the probative value, it's relevant. I want to be real clear. There's nothing we're talking about here that is irrelevant. The evidence that would be deferred. I'm trying to weigh the incremental probative value of this jury hearing all about this other stuff when they've heard from two witnesses who have said, those are the guys who were there. I was with them. And they did it, and we did it. And we went back to Young Band's place, and we spread all the stuff out. It is prejudicial, but that's not a reason to keep it out, unless, of course, that prejudice, and keep it out is the wrong word, to defer it till a later point. I'm not seeing, other than proving the count that could be tried by this jury a little bit later, I'm not understanding the incremental probative value for the armed robberies, the home invasions, the aggravated batteries, and the two gun counts.
Because it goes to motive and intent as well. So all of this was planned at a household. If you look at, another reason I admitted the video of the arrest is because of the YSL art and references painted on the wall. There is YSL members all together that planned it there. And defense counsel has done an effective job of some, making some of the records seem confusing. And I think this goes to show that it helps dispel that confusion, to show that it wasn't some sort of random act mistake. This was gang members together.
Isn't the evidence that Riley said, hey, let's do this?
Yeah. And she also said that she was excited to hang out with YSL members, and she liked the thrill of it, and that's why she thought that they would go along with it.
So your considered opinion is that the issues that going into the next two witnesses and the 418 material might present on appeal, if there's an appeal, those are sufficiently minor, and the importance and value of the evidence is sufficiently great that you oppose bifurcation.
Yes, I oppose bifurcation, and for the fact too that I promised.
I can fix the promise. I can fix the promise. I don't disagree. I don't disagree with anything you're saying. I understand both sides of it. I'm struggling with it. So, I mean, other than the first two cases you cited, but I can fix the promise part.
I think I should still at least be allowed to call, if you're going to bifurcate it, I should still be allowed to call Velasquez, because I should still be able to call Velasquez, even if not considering the count.
Okay. I won't bifurcate, but you need to let Miller know that you are going to get very little time marching through that PowerPoint. As a recent survivor of that PowerPoint in another case, we don't need the depth of history and detail, and I will cut it off if we're going into, and this guy founded this one over here, and if we're learning a lot about what went on in Los Angeles, I will cut it off. So you're going to call these folks. I won't bifurcate. And it's not a knock against Miller or you. I'm not going to require the defense to object that we are getting further and further afield. It's about YSL allegedly and a spinoff of YSL. And so we need to get into YSL real quickly. There was about 30 minutes of Miller about stuff about people who are long since literally dead, what was going on in Los Angeles and this and that. All accurate, but not necessary.
I'll cut that.
Excellent. That's the compromise. All right. Then we need to bring the jurors in. They need to hear Investigator Maldonado answer these questions. And we'll probably stop there because you all will get to follow up rather than put Velasquez on for 30 seconds. It's a Friday and the jurors want to get out of here. But I want to be able to tell them when I send them home. Oh, and you should know, one of the jurors asked, with this being, in parentheses, allegedly gang related, are our names sealed or private, or will they be public? So I'm going to address that for them before they leave. And that wasn't one that they submitted. They handed it to Deputy Gordon. So I'll address that. But you're down to 2 witnesses. What's your estimate? I know you don't control cross-examination, but you've now seen cross-examination. You think we're done by lunchtime tomorrow with your case? Not tomorrow, Monday?
I personally do. I was not planning on spending more than 15 minutes with Velasquez on the rack.
Ms. Mignot should have about 2 questions for Velasquez. There'll be an instruction before he testifies that has absolutely nothing to do with Mr. Robinson. You get to ask as many as you want, but I forecast not too many from Ms. Mignot. Mr. Pritchett may have a whole bunch, and he can do that. But it sounds like if you're going to be that brief-ish with Velasquez, that won't be very long. And then it's Miller, who will take longer necessarily, but you're committing to do a Reader's Digest version of the ancient history of YSL and hybrid and more quickly get into the meat and potatoes of this is YSL, this is what's going on in Atlanta and the spinoff, and then all the stuff that I overruled where you've got your iron triangle where we're actually talking about Pritchett and Robinson. That may take a while, but you're proving your case then.
Yes.
Okay. I feel better about that. Ms. Mignot, you're gonna have all weekend to think about it, but I'm wondering if you could give me a preview right now that you've had a chance to, and I don't mean this in a bad way, you're doing your job, beat up on Kalish and Riley, and through Maldonado, beat up on them some more. Do you envision calling either of them back or any of their parents? And you're not committing right now, but if you were crystal balling it, do you envision doing any of that?
If I'm crystal balling it, not holding me to it.
None of this is holding you to it.
No.
Okay. But like I said, you have all weekend to think about it, and you and Ms. Blake, I'm sure will have a skull session, and it may change, but currently you don't see reeling any of it. We're bringing Ms. Riley back on Monday as a just in case, but you currently, based on the effectiveness of your cross-examination of those 2, and then through Maldonado, you don't envision bringing them back. Okay. All right. Mr. Pritchett, now's the time to tell me what witnesses you thought you might call if you present any evidence. You don't have to present any at all, but that might be on Monday when it's time to do that, whether it's you testifying or you having other witnesses present.
I have a list of names. Some of them are already on this state's witness list.
Okay.
But like they're Reeve says, like some of them may or may not be called. It's just
right. So you're giving me a list of potential witnesses. All right. Can you share that?
First one is Lauren Riley. Second one is Jackson Buckingham. Third one is Lindsay Kalish.
Look at the state.
Fourth one is Alex Ellis.
Who would that be?
Friend.
A friend of yours? Yes. Okay. You spell it standard spelling, Alex, and then Ellis, E-L-L-I-S.
He's dragging his friends into court with him. Oh, no.
The next one, I guess the fifth one, would be Voss Coleman. Sixth one would be Holden Carmody.
He's recalling all the witnesses.
Next one would be Officer R. Wright.
Is that, okay. She testified, but she's now Weems, I think, but that's the one who already testified?
Yeah, I believe that is.
Okay.
Judge has to subpoena all these people.
The next one would be Marquise Abdullah.
Is that on the list, or that's someone you know?
It's somebody on the list.
Marquise and then Abdullah?
Yes.
All right.
Next one would be Amber Hannons.
Spell the last name?
H-A-N-N-A-N-S.
All right.
And the next one would be Maldonado.
Well, he's testifying right now. How would you possibly, why would he need to come back again?
Just if like some important, because all the time that I take when I'm back, I kind of just research and do other things, but I may have some more potential questions.
Okay, so the way the process works is generally I'm gonna call it 1 1/4 bites at the apple. You get your direct and cross, and then there's redirect and recross. That's the quarter of the bite. It would have to be something extraordinary for Mr. Hiles to be able to say, oh, I gotta put Buckingham back on the stand. Well, you had a chance. You don't get to keep doing this. So for all the people who've already testified, you need to let me know, well, 2 things. One, other than Riley, you need to figure out how to get him here. Riley will be here on Monday, but I don't have the ability to make anyone else be here. But you can work with people you've got on the outside. But you need to explain to me outside the presence of the jury why you're putting them on the stand again. There may be great reasons. Hey, I didn't know about this until a witness who testified after, I'll make it up, Buckingham said, the guy who came in had an eye patch. And then later on, someone testified and said, there's no eye patch. They were wearing masks or something that you only learned after Buckingham testified. So you couldn't have asked him about it. That would be a reason to have him come back. Not, hey, it's my turn, and now I'm going to ask him some questions. Because you already had an opportunity to ask Mr. Buckingham questions. But we can talk about that Monday morning. Ellis, Abdullah, and Hannons, you don't have to tell me anything about them, but you need to understand that, and Coleman, the 4 of them, the thing they cannot do when they come in and testify is provide alibi testimony. Okay, you understand that?
And I may be.
You have an absolute right to do that. You can say anything you want when you're we'll work through it, but there's a different set of rules governing if you choose to testify. Okay. Mr. Hiles, do you have any questions we need to work? Well, we'll do that. Let's get the jurors back in here. And then we'll, if you have questions or concerns about that witness list, I'm committing to having Ms. Riley back here on Monday. I think that it ends my involvement in all that.
Yeah, and anything so Ms. Riley is represented, so any communications with her need to go through her attorney as well.
Same with Kalish. Right. Okay. Let's bring the jurors back in, get through these questions and the follow-up, and let them enjoy their weekend.
Any chance we can do last ones today?
If they want to stay late.
It'll be quick. I think we get them up and down.
You have less credibility than you'd like in that space.
I remix the song. I'll give you a little taste. Ready?
Okay, that's good to know. So it won't be quick.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From leg t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells, all rise and pay respect to the one and only go to true crime. Imitators, they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe because there will never be another creator like
than you may have thought you were going to have. I was engaging with all the parties to see where we are in the process, ways in which things might be tailored to fit in the allotted time, et cetera. I'm going to talk to you about that in a little bit, but we left Investigator Maldonado hanging in witness limbo. So I have a few questions for him based on your questions. We'll see if there's follow-up and we'll go from there. Let's start with young bands. Explain to the jurors why you never sought a search warrant or consent to search that apartment that is associated with young bands and certain aspects of the allegations of this case?
Sure. At the current schedule that I had, I came in at 4 p.m. The Atlanta Police Fugitive Unit typically conducts their search warrants earlier in the day. I was notified, hey, we've cleared the scene. We're bringing Mr. Pritchett to headquarters. And it was at that point that I responded. So the scene had already been unsecured. Anything of value in the apartment probably would have been gone at that point in time. And that was my reasoning, is to not elect to seek a search warrant for the apartment.
So I'll make sure I'm clear. I'm not talking about 1040 Wiley. You're talking, so you also were notified however many days later that someone had been arrested in or near the young man's apartment, and that's what you're referring to?
Yes, that is what I'm referring to. It was an address, I believe, on 14th Street.
Okay. Any reason, when did you first learn that that address was an address of interest to your investigation?
Upon speaking to Ms. Riley and Ms. Kalish, they mentioned that they, when they finally got around to mentioning young bands, mentioned that they had met up at his apartment in Midtown. They weren't exactly sure of the address in Midtown, but pointed to being a condo in Midtown. And then eventually we were able to determine where he lived at. And that's how that address became of importance.
Okay. But that would have been November 16th or later that you figured out the address that was associated with young bands.
That is correct.
If the scheme to do this home invasion was allegedly planned at young band's condo and you received evidence, these are all assumptions, you can tell the jury, I didn't know that, I did know that, and you received information that young bands was involved in the planning part of it, why didn't you investigate him further as, I guess we could call it a co-conspirator?
So upon learning about how the incident was planned at his apartment and how allegedly they had made, he and allegedly Mr. Pritchett had reached out to people to be involved in this robbery, I considered the possibility of looking at party to a crime, essentially charging them with the same exact charges, even though he wasn't physically at the apartment, kind of similar, or the apartment, 1040 Wiley Street, similar to how Ms. Riley and Ms. Kalish were both charged, even though they weren't physically the ones that committed the robbery. Had a discussion with members of the DA's office and felt that at that point in time, we didn't really necessarily have enough that could be a successful prosecution against young bands or Boz Coleman. And as a result was the reason why charges weren't sought for his arrest.
Is that a decision ultimately that the district attorney's office gets to make or you get to make?
Ultimately, as an officer, I have the discretion for the charging. However, I'm not the one prosecuting a case. I'm not the one that has to put things before a jury. And so I relied on their recommendations since they are the experts in the courtroom per se.
Got it. You described viewing different surveillance footage around the 1040 Wiley, the ring camera at 1040 Wiley that showed the door, but also you said there was a neighbor who provided some that showed the car driving around. Can you share with the jury the timeline, what was captured first, how did they overlap or not overlap?
Sure. The incident happened on 1040 Wiley Street. Wiley Street intersects with another street called Weatherby. And there was a house on Weatherby that had an extensive amount of cameras. Those cameras were motion activated. So they're not constantly running. It's just when it detects something, kind of similar to how Ring cameras or Vivint operate now, it detects motion and starts recording. So it picked up the vehicle when it stopped next to the house. And then when it gets activated, it records for about 30 seconds and then it kind of stops again, which is why we only see the vehicle when it's coming through at different segments. The Mercedes in question turned down Weatherby, coming from the direction of 1040 Wiley Street, made a U-turn and then parked in front of the house. And so that's when it was captured. And then when it went later on, it went straight through the intersection of Wiley Street and Weatherby and just sat at a stop sign with its lights off. So that's how we're able to see that. But that was, and I don't have an actual map in front of me to give you the exact distance, but it's just an estimate of maybe 4 to 6 houses down from the Wiley Street address. If you travel westbound, Weatherby is the next street, and then the cameras came from that intersection.
If you were to place the different video segments chronologically, would all the Weatherby segments have been recorded before the footage that showed white jacket, I think that was Kalish, and red shoes, Riley, going inside the 1040 address, or after, or the same time?
So the footage when the Mercedes first appears on those Weatherby cameras is prior to everything. As I testified before, you could actually see a female sitting in the passenger seat. And then the footage that I confronted Ms. Riley with during the initial interview, or the second interview when we brought her back, is the fact that her vehicle, via timestamp, was driving around while she was allegedly inside of the party.
The Rick Rare and 1100 Baby Slat Instagram names, did you come across those through Ms. Riley's Instagram friends list or Ms. Kalish's, or some other way?
They came from Ms. Kalish's followers and following list on Instagram.
Did you search through either Ms. Riley or Ms. Kalish's messages on Instagram to see if there were any messages between Kalish and Rick Rare or Baby Slat, or Riley and Rick Rare or Baby Slat?
I did, and I was not able to locate it.
Do you recall the dates, or are you able, by looking at your report, to figure out the dates when you obtained the records from Instagram and the phone records?
That would have to refer back to it again.
Please do. In particular, the Instagram. So I think there's Riley Instagram and Kalish Instagram. And Mr. Howes, if there are exhibits that we could show Investigator Maldonado so we can find it sooner, it don't even need to be on the screen. If it's in evidence, we could just put it in front of him. Let me put it in context. The ultimate question is this, about how far did the preservation requests go in and these requests to Instagram occur after the incident, such that, gosh, things could have been deleted. Obviously, it wasn't instantaneous. You weren't even on the case right away. But the inquiry is, how much time passed from November 8th, 2019 to you getting to Instagram saying, don't delete anything else for these addresses of interest?
So the preservation was submitted that same day of the interview on the 16th. So it would have been 8 days after the robbery, but I would need to see the warrant for recollection as when I actually obtained the search warrant.
But once the preservation letter was in, even if you did the warrant 3 weeks later, there shouldn't have been anything. Once Instagram or Meta received that letter, nothing more should have been deleted from their servers. The user might think he or she deleted it, but if your warrant was valid and they scoop it up for you, you would get even that which was attempted to be deleted after the preservation letter.
Right. It would be that. It was that 8 day time span before that preservation was put up.
All right. You don't need to look anything else up. That covers that. You have been presented with some paperwork that associates Mr. Robinson with the handle Baby Slat, but also the Goat 1100. Are you able to tell from your review of the records if those were names or monikers used simultaneously, or if there was a switch from don't call me Baby Slat anymore, call me the Goat 1100, or vice versa?
So there's only one Instagram handle that's used at a time. The records would show when all of a sudden you see a change in there. However, at that exact date, I would have to refer back to the records to give, but they can't be used simultaneously.
Do you know which was used first in time?
I would have to double check. I would have to double check.
Okay. Mr. Hiles, do you know of a way to navigate us through whatever state's exhibit that is?
I think I can. I can find it eventually.
Well, me too.
I don't know if I can navigate it right now.
Okay.
I think it's a controlled search. There is the records that are reflected at the time the warrant was written, and then they're duplicated in the same records as to what they look like when the preservation.
Okay, it sounds like the answer that will stand is they couldn't occur simultaneously. You're not sure which one was used first.
Correct.
Okay. Mr. Hiles, do you have any follow-up for Investigator Maldonado based on our recent exchange?
No.
Ms. Mignot?
Just one, Your Honor. Detective Maldonado, you said that the video for the Weatherby video, it picks up the motion when the Mercedes is coming around. It would also pick up motion if two men are coming out of it, okay?
As long as they were on the sidewalk closest to the house, yes.
Yeah, where the vehicle is, where we can see in the video.
Correct.
And that footage doesn't show any men coming out of the vehicle, correct? Or going into it.
Right. The car, you see it parked on the sidewalk, and then the next time you see it, it's to the intersection.
Thanks, sir. That's it, Judge.
Thank you. And turning to the accused, sir, do you have any follow-up for Investigator Maldonado?
On the footage that she was referring to, you said it only showed a driver.
You can't see the driver. You can just see a white female in the front passenger seat. And as I testified before, I would assume there's a driver simply because the vehicle is moving and someone has to be in the driver's seat.
Overall, it showed passenger.
A front seat passenger, yes.
That's it. All right, Investigator, thank you so much for your time.
Thank you, Judge.
It's 5 on a Friday. You've been with us all week. You're going to leave in a moment. I need to address a few things. One, your names are not a public record. The documents that had your names on them have been retrieved from everyone and shredded. I have the one remaining set, and I have it only because when the trial's over, I send you a thank you letter. That's it. And we need to call or email you if you don't show up. There will ultimately be a full disclosure, a document filed with the clerk's office indicating the number of days you served. I have to certify that so you get paid. If I don't, you don't get your huge check that you're going to get. And in fact, Ed McMahon delivers it at your door. It's giant. It's a big cardboard thing. It says 11 cents. But that document is filed under seal. Part of your break was spent by us talking about what's next. Mr. Hiles swears under oath. 2 witnesses left. One of the witnesses for the state will be very, very brief. Will likely be very, very brief for one of the defendants, but not for the other. This witness is going to be one of the ones that I mentioned during my initial instructions. Will be providing evidence that is admissible only as to one of the defendants. It's going to be Mr. Pritchett. And so he may have a bunch of questions on cross. Ms. Mignot can as well. I suspect she won't, but she is creative and she may. But Mr. Hiles is saying his examination will be brief. That leaves only one other witness. He will take longer for the state and likely for both of the folks doing questioning on the defense side. And then the state will rest. When the state rests, you get a break because we have to work through some legal issues. And then we will hear from Ms. Mignot if she's going to be presenting any evidence on behalf of Mr. Robinson. 0 burden for either defendant. So as I told you before, she may say, nope, we rest. And she will rely on the evidence, lack of evidence, and conflicts in the evidence that she has highlighted during her examination, cross-examination of the witnesses. And then the accused gets the same opportunity. He has an absolute right to testify if he wants to, not testify, call witnesses if that's something he is able to do, but he is authorized to do that. And we'll see how that goes. after the state rests, but I need you back here Monday morning, 9 a.m. We're going to be apart from each other a lot longer than before, but I need you to maintain your commitment to no outside influences, no outside research. You have so many other things you can talk to friends and family about than this case, and just keep it that way. We will see you at 9 on Monday. Any questions about anything I just shared with you? Excitement level like 99? Excellent. That's what I thought. You guys have a wonderful. Oh, now all of a sudden there are questions. Let's start with you. Yes, ma'am.
I was going to probably say the same thing. Do you have any idea how much longer we're going to be here beyond Monday?
I don't. The unknown is what evidence, if any, either defendant is going to put up. I'm pretty sure that I'm confident that we will wrap up with the state's case on Monday. I don't know what will follow after that. That will come when you're taking that break. There are motions that the defendants are entitled to make when the state rests. I got a rule on those, and then we'll explore that. But I'm not trying to be cagey. The lawyers aren't being cagey. They've given me a forecast, but they're not held to that. And so I don't want to share it with you, because if it's different, I don't want you to be frustrated with them, because they have all weekend to think about, maybe it's best to do nothing because we've done enough. Maybe it's best to call witness X. In the same way the state does, defendants have the ability to compel a witness's appearance, and then you just flip the role. They'd be doing direct examination, and Ms. Green or Mr. Hiles would be doing cross-examination. So if I had to bet, not legal, don't do it, I guess that we would spend some time together on Tuesday, but I bet that time on Tuesday would be maybe a little bit of the closings, and then you're deliberating. That would be my forecast, but think of that like a weather forecast. It may actually rain on Tuesday, even though they say it's going to be sunny. Okay. Did you have a different question, sir? Okay. Did I not address any of? Okay. I know what your question is. That's always your question. Did you have anything else? No. Let me say this. It is clear to me that I know you are juggling. Let me say this first. We've received 0 Publix baked goods since we've been here. I'm going to just say I've received 0 Publix baked goods. All right. You are juggling a lot. When we take breaks and I'm going back to juggle what I need to juggle, people are on the phone doing work and this and that. And so we all appreciate that this is a huge imposition, and it's expanded because you're having to come back next week. We don't take that lightly. We are not goofing around in here. I think you can appreciate this is a high stakes situation for everyone involved. You've now seen and heard something real bad happen that night. The question is, who did it? And that's why you're here. Appreciate your patience. And I know it is drawing you down. Like, dang, I do have to get back to life. Perspective. The YSL jurors, they're on like month 99. You won't have any months. In fact, if we don't count Monday, because that was jury selection, you'll have maybe a week's worth of days where you served as jurors in an important situation. So know that we appreciate the sacrifice. We don't minimize the sacrifice. We're mindful of the sacrifice. You've had to do a lot of sitting around. There are a lot of moving parts that we need to navigate carefully to ensure that the state gets a fair hearing, that Mr. Robinson and the accused get a fair hearing. And this trial is a little different than some of the trials I've had, and it just makes it a little more complicated. But I need to make sure that I'm ensuring due process for everyone. That may seem like you get no process at all because you're stuck here, but that's not the goal. Okay. That's my little pep talk. I will see you guys Monday morning. Thank you so much. Mr. Hiles, just because you're closest, if you would get on the witness stand is DR 18, that's an exhibit, so it should go to exhibit land, and I think it's your copy of Maldonado. That goes back to you. Thank you. Mr. Robinson, I need to address, I need to wait till we're back on the record. That's okay. No, you were dealing with evidence. I need to address something directly with you, and then I'm going to do the same with Mr. Pritchett. It may come to pass on Monday, latest Tuesday, but I forecast it'll be on Monday, that I need to have a conversation with you about whether you want to testify or not. That is not something I'm going to ask Ms. Mignot about. She'll be in court while I ask it. She'll be right by your side, but it is ultimately a defendant's decision whether he testifies or not. And so I want to make sure over the weekend you think about it, because the one answer you don't get to give is, I need more time to decide. I'm not going to spring it on you. That's why I'm telling you now. But after the state rests and we start having a conversation about, is there any evidence that's going to be presented by either defendant? If Ms. Mignot says either we're not calling anyone, or I currently only plan to call John Doe, but not you, then I need to have that conversation with you on the record, outside the presence of the jurors. They won't hear it at all, about whether you want to testify, your right to not testify. But if you choose to testify, the reality that you don't get to just answer softball questions from Ms. Mignot, but you'd be cross-examined by one of the prosecutors, and Mr. Pritchett would be free to ask you questions as well. Okay? You'll be ready for that?
That could be interesting.
You'll be ready to answer those questions on Monday. Pardon me? You will think about it, but on Monday won't be the time to think about it. Monday will be the time for us to have that conversation. You understand? Okay. Mr. Pritchett, same situation. I know you were getting your papers in order, but it could be that on Monday is when you and I need to have that very same conversation, where I'll be asking you whether you want to testify, telling you your rights. You don't have to, but if you do, you'll be subject to cross-examination by the state and potentially by Ms. Mignot. And Monday won't be the time to say, dang, I'm representing myself. I need more time. You'll need to be in a position to say, yes, I am, or no, I'm not. Okay, great. Mr. Hiles, anything else you want to get on the record at this time? Oh, yes, you may have more, but let me do this. Mr. Pritchett shared 4 + 4 + 1, 9 names of potential witnesses, 3 of whom weren't from your list. Ellis, Coleman, you know who Coleman is. No, I guess 4 of whom, and then this Mr. Abdullah and Ms. Hannons. Are those names that, I know you know who Vas Coleman is. Do those other 3 names ring a bell?
The other names, I have no idea who they are.
Okay.
So if they're going to be called, I just ask for a contact number and date of birth.
So, Mr. Pritchett, before you could call Ellis, Abdullah, or Hannons, you would need to provide to both Ms. Mignot and to the state basic biographical information. So address, where they live, date of birth, and a way to contact them, because don't put me in there. Their lawyers are entitled to speak with them in advance. Your witnesses may say, I don't want to speak with you. They have a right not to speak with them, but they need to be made available in case they are willing to speak, so that the lawyers could say, what do you have to say about this case? So if you're going to call any of those folks, you need to make sure when we come back on Monday, because we aren't starting with you, we still have 2 state's witnesses, that you've got contact information. If you don't have that, those aren't witnesses you can call. The ones from the state's list you don't need to worry about. The state already knows them, and Ms. Mignot has had contact information for them for a while now. Okay? Mr. Hiles, you were going to share with Mr. Pritchett the redacted version of his indictment and sentence and all that. Did you do that? And did he? Okay. Mr. Pritchett, you met with Mr. Abadi, Adam, yesterday. I think he shared with you one of the things the state is going to attempt to admit into evidence is the indictment and then conviction records related to the older home invasion. The originals will go into the record, but the originals make mention of felony murder and the fact that someone died. And I've ruled that this jury doesn't hear about that was part of the home invasion, that the gentleman jumped out of the building and died. And so Mr. Hiles represented to me that he has edited the indictment to take out any reference to felony murder. And similarly with your plea form, there's no reference. You didn't plead to felony murder anyway, but that's all been removed. Did you and Mr. Abate look at those forms?
He showed me the front cover. I know it was wrong enough. He showed me the front page.
Okay, did you feel like the redactions were acceptable, or you don't feel like you're still sure about what the redactions were?
Yeah, I'm not sure what the full redactions were, but I have an understanding of what you said. But like I said, the only page I saw was, I think it was the indictment page, and it said one charge of burglary.
Okay. Mr. Howes, do you have scanned versions or just paper versions?
I've got. This is all.
I don't need the, no, I'm having, which are the edited ones?
This is the edited one.
Okay.
If you're in anywhere in the tornado watch area, please be safe. Please be safe. Pay attention to all the warnings. Take cover. Kansas, Oklahoma, Nebraska. All the usual suspects there.
I thought it was a different sentence. So the revocation was just a 10-year revocation?
No, the original sentence. It's got.
Oh, it was a first offender. Okay, so that's why. Got it. Okay.
We done, Judge?
So is this your only copy? I'm going to hand it right back to you. I
think so.
Okay. Can you hand it to Mr. Pritchett? We're good. Mr. Pritchett, I've looked at the redacted version, and it is what you recall, but you may have only seen the first page. It's the original indictment. All it says is burglary now. It's your initial plea, where you got 10 to serve 2 balance probated to burglary. All it shows is burglary. And then it's got your resentencing by then Judge Millender after the revocation. But again, it just says burglary. My direction was to remove any reference to murder, felony murder, anything like that. And it's all gone. So I don't see an issue with that being what goes to the jury. But I'm going to let you finish flipping through it, and then you can give me your thoughts.
Judge like Kanye, going to let him finish. Just about done here, guys. The jury's been excused for the day. We're just finishing up some paperwork and some points of order that will make court go a little bit faster
This
next
is
week.
coming in for what reason again? Like this is.
So back when you had Ms. Williams, she argued against it coming in, but it's what we call 418 evidence. And so it comes in because I found that it is evidence of another gang-related crime. And there is a rule of evidence that basically says if you're being prosecuted for a gang offense, other gang-related crimes can come in for any purpose. Here they're going to argue propensity, motive, intent, but also, this was discussed at the hearing, evidence that you learned in that case that the way the police figured it out is that everyone had a cell phone with them. And I think, I don't mean to speak for Mr. Hiles, he can get it in for any reason he can argue about it in any way he wants, but I've already ruled that it comes in through this rule of evidence called Rule 418, which relates to gang offenses.
What classified that first case of the gang as a gang offense?
I don't remember, but that was presented, and
it's listed under 1615.3. As a gang activity.
Oh, that's right. It doesn't. The other one doesn't have to be a gang. There was a recent Supreme Court decision that says
he's coiling that. Right?
If that prior crime is the type of crime that constitutes gang activity, evidence of it can come in. So either way, I've ruled it's coming in, and the input I wanted from you was whether you felt the redactions removed any reference to felony murder. I find that they do, but I wanted you to be able to preview it so you weren't surprised. Okay. The only other thing I have on my list for you, Mr. Hiles, was that you were going to revise the Miller PowerPoint consistent with my rulings. You've been in court all day, but over the course of the weekend, you will get that to me and Ms. Mignot.
It's revised. I will email it to you when I get back. I have great assistants that were open while we were
Great, but email it to Ms. Mignot and Ms. Blake as well.
Before 7 a.m. on Monday.
Right, yeah. Whether you have to send it as a PDF or you actually have your laptop connected, make sure it goes out this weekend. All right, Ms. Mignot, anything on behalf of Mr. Robinson?
Nothing on behalf of Mr. Robinson, Your Honor.
Okay, Mr. Pritchett, anything else? I will email to the lawyers, and then we'll get you a hard copy Monday morning.
I think he's
Mr.
given
Pritchett,
up on being pro se.
a draft jury charge. Ms. Niles prepared that, and I will work through it. Now that I haven't bifurcated, I need to go through a little bit more of it, but I'll get that to you all, because in theory, we could have a charge conference on Monday. We certainly need to have that.
And if we could have that also emailed to Ms. Blake.
Oh, no, I sent it to both. Yeah, because you told me you both worked on the proposed charge, so I wouldn't exclude her from that.
I missed that, Judge. What day?
We
The charges?
could have it on Monday. I don't know what's gonna happen on the other, but you guys are resting on Monday, and if the answer is nothing's coming on the other side, but I'll email this weekend to you and all the other lawyers and Ms. Blake, the proposed charge. Okay? It's been a long week. I appreciate everyone's dedication.
Thank you, Your Honor.
Everyone has been on time or had a substitute here when other things were going on. And that's important because that makes us good stewards of the jurors' time. Spend a little bit of time re-energizing this weekend. I know you're going to work on this case, but a little bit both days doing something unrelated to State versus Robinson and Pritchett. Be healthy.
Two defendants are in jail. You're like, unrelated. What do you want us to do? Can you let us out for an extra hour?
Thank you.
All right. And we are done. We're done, which means we get to go to, let's see, let's do a preview here. It's time to play. It's time to play the song. We remixed it a little bit, extended cut. I changed up the timing a little bit, made the words a little more clear, turned down it's not quite as hard, but made some adjustments. I think we have something we can run with. So as you can see, I've got my graffiti up in the background. We are good to go with audio. Make sure it's connected properly. It is. And I just hope this is right. This is such a pain in the butt to edit, so I'm hoping this is good. Here we go.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From land t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells, all rise and pay respect to the one and only go to true crime. Imitators they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe. Because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're too good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal.
There we go. That is our remix with an outro. I tell you, the things you can get done in just one day while watching court. Courtney Meek, thank you very much for the lead-in on this one. See, I told you it thumps. It thumps, man. It's got the bass. So now I have to remix the intro. Anyway, good song. So there's our new intro. I'm not sure if we'll use it every day, but maybe occasionally we'll mix a new intro video for that. And I love it. I'm sorry. Simple minds, simple pleasures. That was great. Let's see. Now we have yoga music, says Red Pen. That's going to be the yoga music. Yes, I'd have to show a picture. I've been stalling, and Amber's dying over there. Amber, who was probably more excited than anyone else about what we were going to do, promptly went out and showed that she was all in. And she did this by doing what? By getting a couple tats. Yes, she got ink done over the break. She's got the RAG life tattoo on the finger, as well as the RAG tattoo next to the eye. So looking good. If you want to follow her lead, that's all on you. That's all I'll say. That's all on you. But we're good. Hey, Mrs. RA, are you here? Did you like the music? I seriously want to download that. I can send you the link, I think, to download it. Let's see. Public copy song. Oh, let's see. Hang on. There we go. Copy song link. Let's see. There's a better picture I sent. That was the best one I got, I thought. Let's see. I see. We'll just share the one for now. It's good. Copy the song link. If you guys want to mix this for your entertainment, let's see what we got here. Let's put it in the chat, shall we? To download the song yourself, you can get it right there. That's the song that we just listened to. Minute 50 seconds long. That's going to be our new intro, or at least one of our intros. I have to send that to Rob. I've got to have a video to go with it. He can't just have audio. We'll work on a video, see if he can see it all. But now I feel cool like the umbrella guy, who just blew me away with his intro. It's awesome. Rag for life, yo, says Nikki Zeebs. That's awesome. You guys are amazing. Let's see. We have, as far as court goes today, it was a little bit slower on the testimony, but we are nearly done. I'm concerned for the state because if the jury does not believe the two girls who admitted to lying to police, okay, that's the problem. They admitted to lying. If they don't believe them and they say, well, they've got a deal, it's in their best interest to testify because if it shows that they helped out, then maybe they might get some leniency on their case, which is coming up. If they don't believe that what they said is true, the state has no case, like no case at all. This is the linchpin. This is the hinge where everything hangs on this case. The fact that the gun isn't being shown didn't make it in. The state couldn't find a way to get the gun shown. That would be very impactful for the jury to see the gun, right? That's the best moment ever when they're like walking in front of the jury with the weapon, right? It's not coming in. It's not coming in because first of all, a gun wasn't fired. But man, all we've seen are some pictures of a pretty lame party by all accounts, some blood on the floor, and a couple injuries, and then a couple kids who the next day just went to the concert. And I'm just thinking that if the jury doesn't buy this, there is nothing to go on. Are we going to watch the hearing on Monday in the Kelly case? I think we're going to try. Dog Lover, I'm sorry. I was thinking of like Nellie instead of Kelly. My mind's doing the whole rap thing now, so I apologize for that. That should be on Monday. We'll hear what happens in the Kelly case. There was fire over at the Daybell, too. I saw a brief clip where the witness was... Chad Daybell's lawyer was questioning the witness, saying, how big is the property around Chad Daybell's home? And the witness turns around and is like, well, you own it now. You tell me. Because Chad did sign over all his property to pay for his lawyer. Great moment. Great moment. Mrs. R.A. heard it. I think she did. She's like, yeah, it's cool. You're cool. Whatever. You guys, serious. We've had our mods and Weather Watch. Well, Weather Watch is a mod too. Been popping these warnings in here. If you get a tornado warning in your area, please take this seriously. This storm and this series of storms. Is it a conga line of storms? Weather Watch is it's life threatening. It's not your run of the mill. Oh, there might be a tornado. Don't chance it on this one. Please be safe. We want you guys to be back here tomorrow. We want you to be safe through the storm. So please take care. Eddie says 4 touchdown tornadoes here. I can see more verses coming. I can't see how to make it any longer. Like I'm limited on lyrics, and I've already paid for the subscription. I can make like 100 songs a month on that software. But This is a real system. Please be safe, all. Appreciate that. So, all right. For those who are not big fans of that style of music, we'll go back to the regular outro. It'll be a little bit calmer. You guys, it's the weekend. It's Friday. It's Friday. I hope you've got some great plans that don't involve building a bathroom. I know how bad that sucks. But good to have you all here. Thank you very much. I appreciate it. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again, which will be Monday morning. Monday morning, where the state should rest in this trial. But it doesn't mean it's necessarily over, because pro se defendant just listed 9 people he wants to call as witnesses. Anything can happen to this part. Thumbnail, says Dog Number. Thumbnail. It's on there somewhere. There's our thumbnail. Let's see, we've added. Well, we've got let's see. Please stay weather aware. Yes, very much so. We've added a few more things from today. We've got the snake. We've got the crab legs are on there. I'll have to look at this a little closer. What's that up in the air? Somebody's walking up here on the top. What's this guy? I have no idea. There's a few things I don't know. We'll have to look at in the morning on Monday. You guys have a great weekend. Be good to each other. Thank you so much for your help. I'm gonna see if I can sign a label, sign a record deal, because I think I've got the talent now that I've got AI on my side. Wonderful. You guys be good, and what do we say? Rag life forever? I don't know. Thanks for joining my club or gang, whatever it is. So we'll see you guys. Have a good one. Oops, that's the wrong one. There we go. Big deal out.